Hello everyone, welcome to Oliveboard. So now in this particular series we are already done with module A and module B. In this particular video we are going to revise our module C. The module C also has so many important acts like the integrated ombudsman scheme is there, consumer protection act, tax laws are here. So very important acts and very important module from your exam point of view. You will see many fact-based questions, scenario-based, as well as case study questions from Module C. So, very carefully, you need to revise this module. We are going to cover all the units from Module C. Let us start with the first unit of Module C. And today we are going to discuss the unit 17A from Module C of our BRBL paper, which is the Introduction to the SARFAESI Act of 2002. Alright, so uh, when we talk about the SARFAESI Act, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. Before the act came into force, whenever the banks they faced NPAs, they had to resort to the civil courts or other courts for the recovery. But this process took a lot of time, and the banks they felt that this time that was involved for the selling of the security under the NPA for the securitization or selling, this led to reduction in the value. By the time the value was actually sold in the market or the money was recovered, the value had gone down in the market. All right, so to solve that situation, the government came up with the solution to set up the DRTs and the DRATs. So now without any intervention of the courts, the banks can get the securities or the assets which are held as securities reconstruction, right, and they can recover the NPAs. All right. So this is the main idea of the SARFAESI Act. Basically, without the intervention of any court, so quickly the banks can get the securities sold in the market and recover their unpaid dues. So now let us start with the provisions, the important provisions, and in this particular act, what all is there. So we know that the banks and the financial institutions they lend money by obtaining security whenever a person, a borrower, goes to a bank to get a loan. Whatever type of charge is created, whether hypothecation or mortgage, anything, right? Something is kept as security. Any asset is kept as security for the loan that is availed by the borrower. Now, when on the due date, if the borrower defaults on the payment, they do not make the payment or there's a default in the interest payment as well, then after some time, this asset will be referred to a non-performing asset. If the banks they do not have enough money, they cannot give it out for lending, right? So banks what they do they obtain the security, and in case there is a default made by the borrower, then they sell the security in the market and they recover their debts. So the security is obtained to act as a protection for the money which is advanced, and in the case of need the money can be realized by the sale of security. So we have already studied the different types of charges which are created, the different types of agreements between the borrower and the lender, in the modes of charges, the different mortgages we have studied about assignment, appropriation, pledge, hypothecation. So basically it is used here whenever the borrower makes a default, so the bank can now sell the security to recover their debts. So the lender has rights over the securities, both movable as well as immovable. Whether we are talking about mortgage or hypothecation, the lender is going to have rights. They are going to have an interest on that security. For the realization of the amount advanced were limited and less effective, since they were required to take help of the legal system, which was taking unduly long time to complete prior to the passing of the SARFAESI Act. So before the SARFAESI Act was passed in 2002, for the recovery of their unpaid debt, the banks had to resort to the legal system, the civil courts, and we know how long it takes for a civil court to give its decision. So this was a very troublesome issue for the banks. Thus, the SARFAESI Act came in 2002 and it solved this problem. So when the SARFAESI Act was enacted, it introduced major changes in the legal framework for the recovery of dues by laying hands on the securities. Basically, the banks, they reached the government saying that to create a provision so that faster recovery of the debts can be made, and the government took the decision of creating special courts, special courts that are going to deal only with the securitization for the recovery of debts. But this was again challenged by the High Court. It was challenged by the Delhi Bar Council, and the High Court held that creation of these special courts was against the constitution, or it was showing that the government does not have faith in the legal system of the nation. But then it was appealed with the Supreme Court. This decision was appealed in the Supreme Court, and the Supreme Court held that yes, special courts should be created, or DRTs or DRATs should be created to resolve the NPAs of the bank. So this was the whole process that took place before the SARFAESI Act came into force. So with the SARFAESI Act, various changes have been made. It has brought legal framework for the following important activities. For, as the name suggests, S refers to the securitization of financial assets, R refers to the reconstruction of financial assets, reconstruction of any interest that is created in the security for the due repayment of the loan as a security interest, irrespective of the form and nature, but when it is not in the possession of the creditor. If, let's say, in a pledge or a hypothecation or a mortgage, the security is not in the possession of the creditor, still, how can the banks get it sold in the market for the recovery of their debt? Then power to enforce such security for the realization of money that is due to the banks and financial institutions. The most important point, without the intervention of the court, because the court takes many years to take a decision, and by that time the value of the security that is provided will go down. So without the intervention of the court for the realization of money that is due to the banks and financial institutions, the act has been enforced. And it also enables provisions for setting up a central registry for the purpose of registration of transactions of securitization, reconstruction, and creation of security interest. So when we were studying in module B, the creation of charges, we said that it is compulsory, or it is not compulsory, but it is mandated that the charges should be registered with the ROC. But here we are saying that a central registry is set up for the purpose of the registration of the transactions of securitization, reconstruction, as well as creation of the security interest. So very important, without the intervention of the court, when the money that is due to the banks, it is realized, and setting up of the central registry. Now let us see some more details about the SARFAESI Act. The act extends to the whole of India, including the state of Jammu and Kashmir, or the UT now, right? So it extends to the whole of India, and it is effective from 21st June 2002. It is also applicable to the housing finance companies whose names are notified by the central government. We are going to see in a separate provision where the act is not applicable, right? So, how does it work? Relating to the enforcement of the security interest applies to cases in which the security interests are created for the due repayment of financial assistance, right? Simply where there is an obligation on the part of the borrowers to repay the loans, and if they're unable to repay, then the securities can be sold without the intervention of the court of law or tribunals by following the procedure which is given in the act for the recovery of loans. So without the intervention of any court, the bank, if they still want to recover their loans through courts, they have that option. But for a faster and better resolution, the DRTs and DRATs are separately set up for the reconstruction and securitization purpose. So whenever the borrower, they are unable to pay the debt, or they are making a default in the interest or the principal, then the banks, they can simply, through the securitization process, through the asset reconstruction companies, they can get the securities realized in the market. So this is without the intervention of any court. Now, this is actually one of the few acts, or one of the few laws which has the retrospective application. When we were studying about the in the previous acts, we said that they have prospective application, which means after the act came into force, then if any activity like PMLA or anything is there, it will be enforced. But the SARFAESI Act is retrospective, that it means that it also applies to the loans and securities which are created prior to the act coming into operation. So before the act came into operation in 21st June 2002, even then, when any NPAs were created, even those can be securitized or reconstructed under the SARFAESI Act. So the SARFAESI Act has a retrospective application. It means that it applies for the loans and securities which were created prior to the act coming into operation. This is another important point. Then the act is applicable to the cases where the security interest for securing the repayment of any financial asset is more than rupees 1 lakh, and the amount due is 20% or more of the principal amount and the interest thereon. So the security interest, which is more than rupees 1 lakh, right? And the amount which is due or which has remained unpaid is 20% of the principal amount plus the interest. This is another condition which has to be fulfilled. Only then the case can be referred to the asset reconstruction companies under the SARFAESI Act, right? The act is not applicable to any security interest which is created on agricultural land and certain properties not liable to attachment. Again, we will see this in the provision when we study where the act is not applicable, non-application of the SARFAESI Act. So the act is not applicable where the interest is created on agricultural land. And the creditors, again another important point, only secured creditors are eligible. So the creditors other than secured creditors are not eligible to exercise rights. Secured creditors are those that get the charge registered. Under the SARFAESI Act, we are going to see a sequence of the creditors that get a priority whenever a security or an asset is brought to the market for reconstruction or securitization. On that, the top priority is with the secured creditor who has gotten the charge registered. So the creditors other than secured creditors are not eligible to exercise the right of enforcement under the act. Then the act has been amended a number of times in 2004, 13, 2016 and 2021. In the year 2020, certain provisions such as section 17, 18 and 19 were enforced. We are going to see in detail about these sections in the further chapters, in the further parts of the SARFAESI Act. So it has been amended a number of times. Now, if we talk about the constitutional validity of the law, does the law have any provision in the constitution? Does the constitution provide support to the enforcement of the law? So this was stated in the Mardia Chemicals versus Union of India case 2004, in which a three-member bench of the Supreme Court declared that this act is constitutionally valid. Also, out of this three-member bench, maximum were in the favor of the constitutional recognition, except a part of section 17 subsection 2. Except section 17 subsection 2 of the act, rest all the act is constitutionally valid. What is this section? It laid down that when the lender intends to take action of taking possession of the security interest, the borrower can file an appeal to the DRT only after depositing 75% of the amount which is claimed by the lender. So it is stated in the section 17 of the act that if a decision is taken by the authority and the borrower is aggrieved by the decision, so they can file an appeal to the DRT, the Debt Recovery Tribunal, or the Debt Recovery Appellate Tribunal, but they can file this appeal only after depositing 75% of the amount which is claimed by the lender. But the Supreme Court declared that this condition of deposit of 75% of the claim is unreasonable, oppressive, arbitrary, and violative of the Article 14 of the Constitution, the right to equality. Right? The Supreme Court held that this decision or this provision of the act, that only after depositing 75% of the amount which is claimed by the lender, only then the borrower can file an appeal. This is against the Constitution. So it was declared that rest of the provisions, rest of the sections are constitutionally valid except the section 17. Also, now the act has been since suitably amended by deleting the condition of the pre-deposit of the amount for filing an application. So now the borrower can file an appeal with the DRT or the DRAT, and they need not deposit 75% of the amount which is claimed by the lender. So this is about the constitutional validity, and it is very important. In which case the decision was taken, so you need to remember this case. Then you also need to see which section was stated as not being constitutionally valid, and this decision, what is related to the section, what does the section 17 states. It states that 75% of the deposit or the claim has to be deposited by the borrower, only then can they file an appeal to the DRT, right? Then the Supreme Court held that this is arbitrary, oppressive of the Article 14, and later on this section was deleted from the act, right? So when you study this chapter, make sure that you remember these points. All right. Okay. So other provisions that we have already discussed in the SARFAESI Act, when the banks, they are obtaining a security and the borrower is making a default in the payment, they can get the security, they can get the asset sold in the market without the intervention of the court, without the intervention of the legal system, because before the SARFAESI Act, it took a lot of time and it was not fair for the banks. Then what else is there? So the act includes the activities like securitization of the financial assets, reconstruction. In the next chapter, in the part B of the SARFAESI Act, we are going to see the definitions. What is the definition of securitization, reconstruction, or the property, or the asset reconstruction company? How the asset reconstruction company has to be registered for the cancellation of the registration. All the provisions are there in the separate chapter. Also, the act extends to the whole of India, and it also extends applicable to the housing finance companies, right? So it applies to the cases where the security interests are created for the due repayment of the financial assistance, where there's an obligation on the part of the borrowers to repay the loan. And if they're unable to repay, then the securities of the loans can be sold without the intervention of the court of law or tribunals, right? It has retrospective application, which means that it also applies for the loans and securities which were created prior to the act coming into operation. That is prior to 2002. If any loans and securities were created, on that also the act will be applied. But it is applicable to the cases where the security interest for the repayment of any financial asset is more than rupees 1 lakh, and the amount which is due is 20% or more of the principal amount. The act is not applicable to interest created on agricultural land, and only the secured creditors can exercise their right of enforcement under this act. Today we are going to cover the unit 17B from module C. Basically all of these subparts are of SARFAESI Act, and today the 17B unit, it deals with the definitions under the SARFAESI Act. So this unit again is very important because you are going to understand the basic definitions of what is a secured creditor, security interest, what is the meaning of securitization, what is the board wherever it is mentioned in the act, the appellate authority, and so on. So definitions are definitely important. Let us start with our session. So when we talk about the definitions in SARFAESI Act, these are given in the section 2 of the act. The section 2 deals with the words or the terms which are used. All right. First, we have the preamble India all about. All right. So preamble is the introductory part which tells us what is the act is about. So the preamble of the SARFAESI Act tells us it is an act to regulate the securitization and reconstruction of financial assets. In the previous session, we discussed why the SARFAESI Act was important, because before the act came into force, the legal institutions or the courts, they dealt with the selling of the property in the market. If in case the banks, they had to recover the unpaid dues, the securitization process here took a very long time. So the government took this decision of setting up the special courts or the DRTs and DRATs, which will specifically be dealing with the securitization and reconstruction of financial asset without the intervention of courts. Without the intervention of courts. So now the banks, they do not need to get a court decree before they carry on with the securitization. They can simply appoint an ARC under the SARFAESI Act. All right. So the preamble tells that the SARFAESI Act is an act to regulate the securitization and reconstruction of financial assets and the enforcement of security interests, and to provide a central database of security interests created on the property rights. So this is an introduction. Preamble is the introduction to the act. Then we have the appellate tribunal. The decisions under securitization, the award is decided by the DRT. If any party is aggrieved by the decision which is taken by the DRT, they can write an appeal to the DRAT, which is the Debts Recovery Appellate Tribunal. After paying a certain fee or after depositing a certain amount of the award which is given by the DRT. So, as per the SARFAESI Act, any person who is aggrieved by the order passed by the DRT can file an appeal to the authority within 45 days. This is very important. When the DRT takes a decision, they send a copy of the order to the parties involved. And if any party, whether the borrower or the lender, they're aggrieved by the decision, then within 45 days, they can file an appeal with the DRAT. But before that, they have to deposit 50% of the claim amount, which can be reduced to 25% if considered justifiable. All right. Then we have the asset reconstruction. What is the meaning of asset reconstruction? There's a difference between reconstruction and securitization. Reconstruction means only the acquisition of the asset by the ARC. So whenever an asset is kept as security by the bank in return of a loan, so the borrower is keeping this asset as security, and if the ARC is acquiring this security or the asset, then it is known as reconstruction for the purpose of realization of such financial assets. So in the case of default, when the borrower is not paying the debt, then for the realization of that unpaid amount, the securitization process is taken by the ARC. So asset reconstruction is the acquisition for the purpose of realization. This acquisition is done by the Asset Reconstruction Company, which is a company registered with the Reserve Bank. In the next chapter, we'll be studying what is the process for the registration application to be submitted for the ARC to commence with their business of asset reconstruction. Can they carry on any business side by side or through a subsidiary? Or what are the reasons for which the registration can be cancelled? Everything we'll be studying. Then the definition of bank means all the banking companies, nationalized banks, State Bank of India, cooperative banks, including the multi-state cooperative banks. Also, the central government can include any other type of bank. So they have included the RRBs as well. Now, whenever we refer to the board here is used to mean the SEBI, Securities and Exchange Board of India. The Securities and Exchange Board of India. So wherever in the act the term board is given, we should automatically connect it to the SEBI. Alright. Then we have the borrower. Borrower means any person who is taking loans by creating a guarantee or a mortgage or a pledge as security for the financial assistance. This borrower can be a person or a pooled investment vehicle. So a borrower, any person becomes a borrower for the asset reconstruction company when the bank is giving loan. This borrower is giving their asset as security. Now, when the ARC acquires this security, then this borrower becomes a borrower of the ARC. All right. So, borrower has the usual meaning of any person who is taking a loan, availing a loan facility or financial assistance from the lender. Now, central registry, very important. Central registry means the registering office set up or caused to be set up by the central government. Here, the central registry is the SARFAESI, which is the central registry for the reconstruction of financial assets and enforcement of security interest. Alright, so the registration system will operate on a priority basis. That is, whoever gets the priority registered first will get a priority in the payment. Whoever getting the security registered with the SARFAESI first is going to get a priority over the person who is doing the registration at a later time. So when we were studying in the module B, the registration of charges, modes of charge, we said that even though if let's say lender A had given a loan first on a mortgage that was created, but they did not get it registered, and lender B on the same mortgage, they have given the loan and they have gotten the charge registered. So when the securitization process is initiated under the SARFAESI Act, the payment priority will be first given to the lender B, who is getting the charge registered first. So SARFAESI has been established as the central registry. The central registry will not only get the charge registered, it will also maintain the database for all the interests that have been created, and the lenders can check on their site, right? Then we have the Debt Recovery Tribunal, which is set up under the Recovery of Debts Due to the Banks and Financial Institutions Act, right? They have original jurisdiction. The DRATs have appellate jurisdiction. They will be involved only if an appeal is made to the DRAT. Otherwise, the original jurisdiction or the first round of award or decision will be taken by the DRT. Moreover, higher appeal can also be made to the courts, High Court or Supreme Court, but only when there is a question of law that is involved. Question of law. Otherwise, the decision taken by the appellate tribunal will be final. Then we have default. Again, meaning of default is the usual meaning: non-payment of any debt or any amount payable, or non-payment of any debt after a notice has been given. Either the borrower has not repaid the principal and the interest, and now the asset is classified as an NPA in the book of account of the secured creditor, or non-payment of any debt or any amount with respect to the debt securities after a notice of 90 days demanding the payment of dues. All right, so when they have delayed on a payment, 90 days are provided. Even then, if the borrower is not obliging, then we will term it as a default. Then what is the meaning of financial assistance? A loan or advance or subscription of debenture or guarantee or issue of letter of credits or any fund. Basically, any credit facility which is provided by the bank or financial institution is a financial assistance. It also includes funds that are provided for the acquisition of any tangible asset on hire or purchase lease, right? Conditional sale or any other contract. Then what do we mean by financial asset under the financial assistance? A claim to any debt or receivables, whether secured or unsecured. By mortgage, we have studied how many types of mortgages. 6 types of mortgages are there. A mortgage charge, hypothecation, or pledge, or movable property. Pledge of movable property is also there. Hypothecation is created on the movable property. Mortgage is created on the immovable property. Then a right or interest in the security, or any beneficial interest on future, existing, accruing, conditional, or contingent base. Any of these will be considered as a financial asset, basically a debt or any receivables. Then we have two terms. We have the originator and the obliger. Originator is the owner of financial asset. In the first instance, originator is the bank who have originated the contract of loan, and they're owning the asset, owning the asset. So the bank or financial institution lends money against a security, so they are the originator. And once this security is acquired by the ARC, so the ARC is going to become the originator. Obliger will be the borrower, the person who is obliged to pay to the originator, whether under a contract or otherwise. So they are obliged to discharge in respect of any financial asset, and it includes a borrower. So originator is the bank or the ARC, or obliger is the person who is liable to make the payment. Then again, very important, qualified buyer. So whenever a bank under the SARFAESI Act use their rights to get the assets securitized or reconstructed, they do so by the ARC acquiring the assets and making a payment in return for the NPA. Then these ARCs, they create what? They create security receipts. They create security receipts and issue them to investors. Now, these investors cannot be individual investors, they can only be the qualified institutional buyers or the qualified buyer. Because this process, these security receipts are marketable, they can be traded in the secondary market, in the trading market, but it requires a lot of experience. So the ARCs do not sell the security receipts to individual or retail investors, but to the institutional or the qualified investors or qualified buyers. So the qualified buyer here will mean any financial institution, insurance company, bank, state financial corporation, state industrial development corporation, SIDC, trustee, or ARC, which are granted a certificate of registration, or any asset management company under the SEBI Act. All right. So these are the qualified buyers who can recover their money by trading the securities in the market. Then we have what is the meaning of a security receipt. When the non-performing asset is acquired by the ARC, then how are they going to recover the money? They are going to issue security receipts which the qualified buyers or the investors are going to purchase, and then they are going to trade it. So it is a receipt or security which is issued by the ARC to any qualified buyer pursuant to a scheme for the purchase or acquisition. Then it evidences the purchaser's undivided right, title, and interest, and also these are transferable in the market, these are tradable. It is very important to remember that the security receipts are issued by the ARC only to the qualified buyers and hold and administer the financial assets for the benefits of the qualified buyers. All right. Then, who is a sponsor? Again, very important. Sponsor can be any entity. The ARC is sponsored by any entity, and they are holding not less than 10% of the paid up equity capital of the ARC. So any entity can become a sponsor of the ARC, but they have to hold at least 10% of the paid up equity capital of the ARC. I hope all of these definitions are clear. We discussed what is the preamble, appellate tribunal, the meaning of asset reconstruction and ARC, bank, board, borrower, central registry, which is the SARFAESI, right? Then we also discussed the particulars of the transactions which are required to be mandatorily registered with the SARFAESI, like all the particulars of creation, modification, or satisfaction of security interest. Then for the creation, modification of any security interest other than mortgage by the deposit of title deed. Also, the SARFAESI will maintain a database of all the security interests that are created with the registry. We also discussed the debt recovery tribunals. So if we talk about the DRTs, the act is applicable only to the cases where the amount of debt due is rupees 20 lakhs or more, right? So this is another very important point. 20 lakhs or more is due. Plus, if we talk about the DRTs and DRATs, so there are currently 39 DRTs and 5 DRATs that are established in the country. Across the country, they are functioning. Apart from that, recently the EDRT project has also been implemented by the government, implemented in all the DRTs and DRETs. So it aims to bring in improved access, efficiency, and transparency. So the EDRT is going to provide the e-filing of application or the payment of fees through the electronic mode. It also generates the list and the case information for viewing of the case status, the orders, and the judgments, right? So EDRT again is a very important step that is taken. Then we discuss the financial asset, financial assistance. There's also the definition of hypothecation, which is given in the act. So hypothecation, a charge which is created upon the movable property, either existing or future, and it is created by the borrower in favor of a secured creditor. We have studied about hypothecation in detail in the modes of charge, right? Also, the definition of an NPA, a non-performing asset, you already know. It is a substandard or a doubtful or a loss asset in accordance with the guidelines which are issued relating to the asset classification by RBI. And it is very important under the act as well that is classification be done as per the RBI directives. All right, then other things: originator, obliger, property can be immovable or movable property, any receivables or intangible assets like the patents, copyrights, trademarks, license, or any other business or commercial right. All right, then we also studied the securitization, which is the acquisition of financial asset, right? How the securitization is done, what is the security agreement and the secured asset, where the security interest is created, it is a secured interest. Secured creditor is any bank or financial institution who is getting the charge registered, right? So all of these things are there in the definition section 2 of the act. So today we are going to cover the unit 17C of module C, which we are covering the important topics of the SARFAESI Act, and this is the regulation of the securitization and reconstruction of financial assets of the banks. So when we talk about the securitization and reconstruction, it is done by the ARC. Before ARC starts with its business of reconstruction and securitization, we have already seen the definitions. They need to obtain a certificate of registration, and once they receive this certificate, it can also be cancelled. We are going to see these provisions. Then when the reconstruction process has started, what measures can be taken by the ARC? Do they require to give a notice to the borrower? Or when the measures are taken, then how the enforcement of security interest is made, what is the procedure for that? All of these things we will be covering in this particular unit. So let us start. First, like I said, in the process of securitization or under the SARFAESI Act, it is said that whenever a bank they face NPAs, the unpaid dues, they can directly refer it to the ARC without the intervention of the court, right? So for any company or any entity, if they want to commence or carry their business of securitization and reconstruction, first they need to obtain a certificate of registration from the Reserve Bank of India. So where do they apply for the certificate? In the prescribed format to the RBI. Second eligibility criteria is that they should have the owned funds at the time of registration not less than rupees 2 crore or any such higher amount which the central bank may specify. So first they need to ensure that they have the owned funds of rupees 2 crore at the time of registration. Then the prescribed format which is prescribed by RBI, they have to make the application, right? Then such registered companies, they can raise money for the acquisition activities by the issue of security receipts, and this act has provided the legal framework for this activity. And depending the nature of the security asset, the RBI has also the power to specify the different amounts of owned funds as they deem fit on the company. Also, if the ARC, they want to make a substantial change, any substantial change, they want to modify the name of the company, or let's say they want to modify the registered address, for that also they need to get prior approval of RBI, prior approval of RBI for making any substantial change. If however they fail to get the prior approval and they make that change without the permission, then their registration can also be cancelled. All right. So for starting with the business or for making any substantial change, they need to obtain the approval of RBI. Now, once RBI receives the application, they're going to check, they're going to see certain conditions, whether they are fulfilled or not. What are these conditions? RBI will see that the ARC has not incurred any losses in the 3 preceding financial years. So the ARC has to ensure that in the 3 preceding financial years they have not incurred any losses. Then the ARC also need to ensure that they have the adequate arrangements for the realization of the financial assets. Like they should have investments from the qualified institutional buyers. They should have ready the funds so that they can make payment to the financial institutions, so they shall be able to pay the periodical returns and redeem on the respective due dates on the investments made by or made in the company by the qualified buyers. Then the RBI will also see that the directors of the ARC, they have adequate professional experience in matters related to the finance, securitization and reconstruction, so that they can take the necessary decisions and these decisions should be correct. So the directors of the ARC, they should be professionals. They should have adequate professional experience in these matters which are undertaken by the ARC. Then they will also see that any of the directors have not been convicted of any offense involving moral turpitude. They should be of a good nature. Their background history should be clean. Then sponsor, do you remember the eligibility of the sponsor or criteria of the sponsor? They should have a 10% holding in the ARC. So the sponsor of the ARC should be fit and proper in accordance with the criteria which is specified by RBI. Also, it is very important that the ARC have complied with or in a position to comply with the prudential norms specified by RBI. Like if the RBI is asking for any papers or documents for inspection and audit, the ARC should have those documentation ready, right? And finally, they have complied with one or more conditions which are specified in the guidelines issued by RBI for the purpose of securitization and reconstruction. All right. So once RBI has checked, they have conducted their inspection that all of these conditions are fulfilled by the company, then they are going to give the certificate to the ARC, right? And these conditions are given under the section 3 of the act. The purpose for considering the application for the registration. So these conditions have to be satisfied. RBI will conduct an inspection of the or of the records or the books of the ARC. All right. Next, we mentioned that the registration of the ARC can also be cancelled. Now, what are the reasons because of which this SARFAESI Act says that the registration of the ARC can be cancelled? It is given under the section 4 of the Act. The registration is cancelable on the following grounds. if the company ceases to carry on the business of securitization or asset reconstruction. Now the company, they are no longer involved in the business of securitization or asset reconstruction, so the certificate will be cancelled. Or the company ceases to receive or hold any investment. Now the qualified institutional buyers to whom the security receipts are issued by the ARC, if they do not hold any investment or they do not give any investment to the ARC, then also the company will cease. And if the company fails to comply with any of the conditions, like they are making a substantial change in their name or the address or any other thing without the prior approval of RBI, or at any point of time they do not have the enough owned funds so that they can carry on with the reconstruction or securitization business, or if the company fails to comply with any of the directions issued by RBI, if they fail to maintain accounts in accordance with the requirements of any law or any direction issued by RBI, if they fail to submit or offer for inspection its books of account or other relevant documents which are demanded by RBI, or they fail to obtain prior approval of the Reserve Bank for change in the management or change in the registered office or change of name. So substantial change, if they are making the substantial change without getting prior approval of RBI, then also their certificate of registration will be cancelled. Now this cancellation, there are certain areas where there's an opportunity which is given to the company to be heard, and in certain cases where no opportunity is given. So there are two categories. In the first category of the cancellation of registration is without giving any opportunity to the company, if they cease to carry on the business or they cease to hold any investment, they fail to give the accounts and documents, they fail to maintain the accounts. Although there's a second category of cancellation where an opportunity to comply with the defaults are given. But apart from these, so which reasons no opportunity will be given? First, where the company ceases to carry on the business of securitization, right? We will mark it. In this case, no opportunity will be given and the registration will be cancelled, or they cease to carry on or hold any investment from the qualified institutional buyer, or they fail to comply with the RBI directions, they fail to comply with any of the RBI directions, or they fail to maintain accounts in accordance with the requirements of RBI, and they fail to give accounts and documents to RBI for inspection. Other than that, they can be given an opportunity that if they correct the default, then the cancellation can be avoided. All right. So these are the conditions. And whenever the securitization or the ARC's registration is cancelled, they can also prefer an appeal, but this appeal has to be made within 30 days of when they receive the order from RBI. And this communication or this appeal is to be made to the central government. Very important. They are making this appeal within 30 days when they receive the notice, and this appeal is made directly to the central government. Then the central government, after their scrutiny, they can decide whether they are going to approve the cancellation or not. Now, regarding the notice to the borrower, if the banks are exercising their rights under the SARFAESI Act, do they need to give notice to the borrower? So when the bank or the financial institution decides that the financial asset be now acquired by the ARC, then a notice may be given about such acquisition to the obliger. You know, there's a difference between the originator and the obliger. Originator is the bank or the financial institution, obliger is the borrower, right? But giving of such notice is optional and not compulsory under the act. So the bank, they would uh, decide to give a warning notice to the borrower that if within such time period you do not make the payment, you do not pay the undue part of the loan, then your security or the asset that you have provided will be acquired by the ARC. But this giving of notice is completely optional. It is completely optional. However, if notice of acquisition is given to the borrower, it is necessary that the obliger should make payment to the concerned ARC, right? If, however, they do not make the payment, then the acquisition, reconstruction, securitization will start. So if a question comes whether giving of the notice is optional or not, then you should remember it is completely optional at the discretion of the bank or financial institution. Then when we talk about the security receipts, which are the transferable, marketable receipts which are created, these are created so that the ARC can raise funds for the acquisition of the asset, but only the qualified institutional buyers or any other category, including the non-institutional investors specified by RBI, can buy the security receipts. So these security receipts can be issued only to the qualified institutional buyers. The security receipts are not issued to the public. Why? Because the investment and the financial market in this field is very complex and much risk is involved, and the retail individual investor do not have such expertise. So the act has debarred individuals from making an investment in the ARC. Again, a very important point from exam point of view. If you are asked whether individual investors can invest in the ARC or the security receipts can be issued to individual or retail investors, so no, only to the qualified institutional buyers, the QIBs. Then the QIBs, they deal with the receipts in the market and they generate the or they realize the security receipt. If, however, there is the event of non-realization, then the QIBs, which are holding receipts of not less than 75%, they can hold meetings and they can decide, and every resolution which is passed in such meeting will be binding on the ARC. But here the condition is 75% should be held by them. Then next we have the measures of asset reconstruction. Whenever the assets are acquired by the ARC, there are certain steps that they can take for the reconstruction of the asset. This is given under section 9 of the Act. Under section 9 of the Act. First step could be change in the management or proper management of the business of the borrower. If the ARC feels that better decisions can be taken, it would result in profit for the company and they'll be able to pay back the dues, then proper management can be one step. Another measure could be sale or lease of part or whole of the business of the borrower. Rescheduling of the payment, more time can be provided. If the ARC feels that the borrower is of a genuine nature, they can pay back the debt if more time is provided to them. So rescheduling of the payment of debts. Enforcement of the security interest will be the final step that would be taken if any of the other steps don't work. Settlement of the dues, the ARC might give time to the borrower, and if the borrower pays the debt, then their assets will not be sold in the market. Taking possession of the secured assets in accordance with the provision, and conversion of any portion or debt into the shares of the company, and then keeping the shares in the market, right? So it is to be made sure that the exercise of powers should be subject to the existing laws. They should not be against or they should not be detrimental to the borrower. Also, there is no civil appeal provided for any action which is taken under this section, right? There's no provision for the statute having an overriding power on the loans agreement between the bank and the borrower. So all of these points have to be kept in mind when measures are taken for asset reconstruction, right? Also, if there is any dispute between the financial institution and the ARC, as well as the qualified buyers relating to the securitization and reconstruction, so for the resolution of dispute as well, the Act has provisions. So the dispute may be amongst any of the parties that are mentioned, that is the bank, financial institution, and the ARC. But here it should be noted that the three parties, they do not include the borrower. So the provisions of the dispute between these three parties, it requires arbitration and reconciliation between the three parties, which is the ARC, the bank or the financial institution, and the qualified buyers, but not the borrowers. Not the borrowers. So for the resolution of dispute between any of these parties, it is provided in the Arbitration and Conciliation Act of 1996. So here, the concerned parties, if they agree for a settlement, for a dispute through arbitration and reconciliation, that is provided, but the provisions of mandatory arbitration and conciliation are not applicable to the dispute by or against the borrower. So this is a very important point. Today we'll be covering the unit 17D from our module C, which is enforcement of security interest. So under the SARFAESI Act, how can the banks start or initiate with the process of enforcement of security interest? How the creditor can enforce, and what will be the role of the DRTs and the appellate tribunal, how the appeal can be filed, everything we will see. So we know that under the SARFAESI Act, the secured creditor can enforce the security interest in his favor without the intervention of a court or tribunal. So this power is given to a secured creditor, and it has an overriding power over the provisions related to the mortgage in the Transfer of Property Act 1882, right? The SARFAESI Act speaks about the notice to be given to the secured creditors, to the borrower who has defaulted. So before we initiate with the security interest, the borrower will send a notice to the borrower. The precondition to get the right to serve this notice is that the notice should be given asking the borrower to discharge his duties in full, his liabilities in full within the 60 days from the date of the received notice. Failure to do so by the borrower, the secured creditor can get further rights which are detailed in the Act. All right, so within 60 days, if the borrower does not pay off the liability, then the initiation of the security interest will be there. All the rights will be given to the secured creditor, right? In the notice, details of the amount payable, the details of the securities will be given. Then, other than that, the overdue period, facility-wise securities provided, other details can also be given. However, the Act does not contemplate a reply from the borrower to the notice. The borrower may reply or make representation to the notice so received by him, right? Then the reply for which has been received by the secured creditor, they must apply his mind to the objection which is raised by the borrower. An internal mechanism should be evolved to consider the reply of the borrower. Meaningful consideration, if it is there in the objection, then execution should be taken, right? If the borrower does not pay in full as per the notice, such non-payment by the borrower gives the right to the secured creditor to take recourse to the measures. Like they can take possession of the secured assets, they can take over the management of the secured asset, they can appoint a person as manager to manage the security, right? So one of these measures can be taken. And when the sale of the secured asset is made, the appropriation of the sale proceeds are required to be made. Firstly, towards the costs, charges, and expenses for those who are recoverable from the borrower, like insurance premiums, etc. Second, payment towards the dues of the secured creditor. Thirdly, if there is any surplus, it will be paid to the person entitled thereto in accordance with the rights and interest. All right. If, however, the borrower pays the entire dues, then the secured creditor shall not sell or transfer the secured assets and no further steps shall be taken for the sale or transfer. Right? So this is done in the first points. Within 60 days, the reply will be given, or within 60 days, the liabilities have to be fulfilled by the borrower, or else the secured creditor will get all the rights which are detailed in the act. Now, when the secured creditor is taking over or taking possession or control of the secured asset, or when the secured asset is required to be sold or transferred under the SARFAESI Act, then the secured creditor can take help of the chief metropolitan magistrate or the district magistrate or any officer which is authorized by them. They can take help of these officers. And for seeking such help, the secured creditor has to make a request in writing to the said authority within whose jurisdiction the secured asset or document related to it are situated. Right? So, for the compliance of the provisions, the metropolitan magistrate or the district magistrate will take such steps or use or cause to be used whatever necessary to make the transfer or sale in favor of the secured creditor. Now, what is the manner and effect of takeover of the management? So, when the secured creditor or the ARC takes over the management of the business of the borrower, they may publish a notice in a newspaper. This notice should be published in two newspapers, in a English language newspaper and in a newspaper which is published in an Indian language in circulation in the place where the principal office of the borrower is situated for the appointment of as many persons as it deems fit. All right, and on publication of such a notice, the directors of the company, the person holding any office, direction and control will shall be deemed to have vacated their office. So this publication of notice is important, right? And then after, the appointments of directors or administrators will be done, will be appointed. All right. So there will be no compensation to the directors for the loss of office in this regard. There's also the provision of making an application against the measures to recover the secured debt if any person, including the borrower, is aggrieved by any of the measures which are taken by the secured creditor for taking possession of the security, then they may make an application along with the prescribed fees to the DRT having jurisdiction within 45 days from the date on which measures are taken. So when under the SARFAESI Act, the secured creditor is taking any measure, any step, and any person is aggrieved by that order, they can make an appeal to the DRT within 45 days on which such measures are taken. Right? And obviously, the application is required to be filed before the DRT within whose local limit the jurisdiction of the cause of action is there, or where the secured asset is located, or the branch or the financial institution is maintaining an account. Right? If the DRT, after examining the facts and the circumstances, they come to a conclusion that any of the measures which are taken by the secured creditor are not in accordance with the provisions of the Act, then they can declare the recourse to any one or more measures to be invalid, or they can restore the possession of the secured assets or the management to the borrower or any other aggrieved person. They can also pass such other direction as they consider appropriate. However, if the DRT declares that the recourse taken by the secured creditor is in accordance with the provision, then the secured creditor shall be entitled to take recourse to any one or more of the measures to recover the secured debt. All right. So these two decisions can be taken by the DRT. Appeal can also be made to the appellate authority. The appellate authority, any person who is aggrieved by any order made by the DRT can prefer an appeal along with the prescribed fees to the appellate tribunal within how many days? Within 30 days. Within 30 days, right? And this fees can be prescribed, it can be different for the borrower's appeal and an appeal by anyone other than the borrower. All right. Other than that, the time limit which is given for the disposal of the complaint, the DRT has to dispose of the application in accordance with the provisions of the Recovery of Debt Due to Banks and the Financial Institutions Act, the DRT Act of 1993. The application has to be disposed of within 60 days. Within 60 days. And we have already seen that a higher appeal can also be made to the DRAT. Now, according to the amendment which was made to the Act in November 2004, it has stipulated that no appeal can lie unless the borrower deposits 50% of the debt which is claimed by the secured creditor. Again, the tribunal has powers to reduce this amount to 25% of the claim. Then there are the rights of the borrowers for the compensation and the cost as well. And that is all. Today we'll be talking about the Central Registry, which has been established by the SARFAESI Act. So under the SARFAESI Act, there's a provision for the establishment of the Central Registry under the section 20 of the Act. And as per this section, the central government may by notification set up or cause to be set up from such date as it may specify in such notification a registry which is to be known as the Central Registry. And the purpose will be the registration of the transaction of securitization and reconstruction of financial assets and the securitization of interest. So both under the SARFAESI Act, the securitization and reconstruction, as well as the creation of security interest, these responsibilities are given to the Central Registry. Head office as decided by the central government, the territorial limits within which the office may exercise its functions, again decided by the central government, right? So basically, for the purpose of providing a central database in consultation with the state government or other authorities that is operating the registration system for recording the rights over any property or creation or modification or satisfaction of the security interest will be done with the system records of the Central Registry. All right. Now, the registry has become operational on March 31, 2011 to prevent the frauds in the loan cases involving multiple lending from the different banks on the same immovable property. Prior to the SARFAESI amendment rules of 2016, the banks and the financial institutions were required to register all the types of mortgages with the SARFAESI. Now we will see the post amendment rules 2016. The transactions and the charges which are required to be mandatorily registered are all the particulars of creation, modification, satisfaction of the security interest in respect of the equitable mortgage created, all the particulars of creation, modification, or satisfaction other than the mortgage by the deposit of title deed, that is the equitable mortgage. Then, in respect of hypothecation of plant and machinery, stock, book debts, whether existing or future. And finally, the security interest in the intangible assets, being know how, copyrights, trademarks, or any other asset of the similar nature. So all the creation, modification and satisfaction of the security interest in these type of assets will have to be mandatorily registered by the banks and financial institution. right? So all the creditors, including the secured creditor, will file the particulars of the transactions with the central registry, right? Now, if we talk about the central registrar, again, central government has to appoint by notification a person as the central registrar for the purpose of registration. Also, the central government is empowered to appoint other such officers as it thinks fit for the purpose of discharging the various duties. The central government has brought the central registry under the superintendence of the central registrar. All right. Then, if we talk about the register of the securitization, reconstruction, and security interest transaction, so all the records related to the securitization, reconstruction of financial assets, and creation of the security interests shall be maintained by the central register. They will maintain the record that will be kept fully or partly on computer, floppies, or any other electronic form, and any entry made with the central registrar shall be a reference to such transaction, and the central registrar shall have the control and management of the central register, right? Then these we have already seen. The particulars of the securitization and reconstruction entered in the central register are open for inspection by any person during the office hours on the payment of fees. And same will be applicable if the data is kept in the electronic format. So inspection is also allowed. Then modification, again, we require a separate transaction with the central registry on the satisfaction of the security interest also. The asset reconstruction company or the secured asset shall give the intimation to the central registrar of the payment or satisfaction in full. Then, on receipt of intimation, the central registrar shall order that the memorandum of satisfaction shall be entered in the central register. If, let's say, the concerned borrower gives an intimation for not recording the payment or satisfaction, then the central registrar will give a notice to be sent to the ARC within a time period not exceeding 14 days as to why the satisfaction has not been recorded. And if no cause is shown, no reply is received from the ARC or the secured creditor, then the central registrar themselves will order that memorandum of satisfaction be entered. Today we'll be covering the module C, unit 17F. And this unit basically talks about the various provisions of the SARFAESI Act, and today we'll be discussing the offences and penalties. So the Act has imposed many statutory obligations, right? And there are penalties provided in the Act for the breach of the provisions or the rules or the regulations. So we'll be discussing about the offences and the penalties. Also, which court is empowered to impose any penalty for the breach of the provision, or how can the application or a complaint be filed that there has been a breach of any of the act or rules or regulation. All right. So now amendment was made, a very important amendment was made in 2016. Before that, certain provisions were existing for the penalties, and then after 2016 the provisions have been changed. That also we'll be seeing. So let us begin. First, when we talk about the penalties. So in the case, if the securitization or the reconstruction company or the secured creditor, they fail to perform any duties which have been stated in the act, then the company and the officers who are guilty for the default, they were liable to pay a fine which could be extended to 5,000 rupees for each day during which the default continues. So these penalties will be imposed on the officers or on the ARC that was appointed for the reconstruction purpose, or the secured creditor even, And but these provisions were existing before the amendment that was carried out in 2016. So if any officer or if more than one officers were involved, they were also liable to pay the fine. So both the company as a whole and the officers, they were liable to pay the fine of rupees 5,000 for each day during which the default continues. And this was before 2016 amendment. Then if we talk about the penalties for non-compliance, again, if RBI has given a direction regarding the securitization or reconstruction, right? And the company or their officers, they fail to follow those directions. For example, RBI wants to conduct an audit or they want to conduct an inspection, and they have given the direction to provide certain documents or information, but the company fails to do so. So that will come under non-compliance. This is given under section 12 of the SARFAESI Act, that RBI has statutorily, which is statutorily empowered. RBI has the powers to issue directions to the securitization or the reconstruction companies. And if any such company they fail to comply with any of the directions, then the company is punishable with a fine not exceeding rupees 5 lakh for the default. And if this default is of a continuing one, it continues for more than one day, then additional fine up to rupees 10,000 per day of the default can be imposed. But again, these provisions were in existence before 2016, before the amendment was made, and these have also been omitted. So we have seen the penalties in two cases. First, if there's a non-compliance of the rules or regulations given in the Act. Second, if there was a non-compliance of the directions that were issued by RBI. All right. In both the cases, the penalties have been given. In the first case, rupees 5,000 and extended to each day. The default continues. Second case, where there's non-compliance of the directions issued by RBI, then the fine not exceeding rupees 5 lakh for the default. Additional fine of rupees 10,000 per day. Now, if we see after 2016, what provisions have been made or what changes have been made or what is the penalty as of now. First, we have defined the meaning of or the term of offenses. So offense means if any person contravenes, attempts to contravene, or abets the contravention of the provisions of the SARFAESI Act, then they will be punishable with imprisonment for a term which may extend to 1 year or with a fine or both. So earlier, before the amendment, the imprisonment provision was not there, right? But now this contravention, non-compliance, they have been made punishable with imprisonment for a term extended to 1 year, or a fine can be imposed, or both can also be imposed. Also, duties are cast on the borrower, the secured creditor, as well as the securitization and reconstruction company. The act now tells us what are the duties of the borrower, what are like the borrower when they receive a notice of the assets being acquired for the securitization purpose, they can no longer sell the property, they cannot transfer the property, right? Or if they want to file a complaint, then they have to do so within such and such time period. The secured creditor, how they are going to make sure that the assets, if in their possession, they're kept secure, and the ARC, they're not taking any restrictive measures, or they're not using, let's say, muscle power for the recovery. And if any contravention of these provisions is done, then it will be considered an offense. And these contravention of the provisions is punishable under the provisions of the section 29. So section 29 becomes very important for us. The section 29 of the act tells us that any contravention of the provisions of the act will be punishable, right? Then if we talk about the cognizance of offenses, cognizance means acceptance or taking notice taking notice. So it is stated in the Act, the section 30 says that no court shall take the cognizance of any offence punishable. There are various sections that have been given. Section 27 related to the non-compliance, or section 23, 24, 25. Various provisions of the SARFAESI Act are given. So the court will take cognizance only when the complaint has been made in writing and the complaint is made by an officer of the central registry or any officer which is authorized by RBI. So if the complaint is made by a officer of central registry or RBI, and the complaint should be made in writing giving all the details as to such and such event has occurred on this date, of this amount, of this nature, all the details have to be provided in the written complaint, right? So only then the cases of the complaint or non-compliance will be accepted by the court, and these offences shall be taken by the metropolitan magistrate or the judicial magistrate of first class only. This is again very important. No other court or no court below the rank of the metropolitan magistrate or the judicial magistrate of the first class can take the cognizance of such offences under the SARFAESI Act, right? So what points are important here? First, no court shall take the cognizance of any offence unless it is provided, unless the complaint is given in writing, and this complaint should contain all the necessary information. This complaint will be made by the officer of central registry or the RBI, and the cognizance or the complaint will be written to or directed to the metropolitan magistrate or the judicial magistrate. All right, these are the important provisions regarding the cognizance of offences. Now, if we talk about the adjudicating authority, first of all, who is the adjudicating authority? It means any officer or a committee of officers of the Reserve Bank of India. Adjudicating authority in this case is the officers of the Reserve Bank, and again these are designated as such from time to time, but these are designated by the Central Board of the Reserve Bank. All right, so the Central Board is going to appoint the officers who will be acting as the adjudicating authority, and then the adjudicating authority, the powers that are available with them to impose the penalty. For example, where any ARC or any person they fail to comply with the directions issued by RBI, or any person who are not complying or going against the provisions of the act, then they are they can be imposed a penalty. Both the company and the person who are in default, a penalty can be imposed on them not exceeding 1 crore rupees or twice the amount involved. If the default is quantifiable, then 1 crore rupees, and if the amount is not quantifiable, then twice the amount of the either 1 crore rupees or twice the amount involved whenever the case is quantifiable, right? And if the default or failure of compliance is a continuing one, it continues for more than 1 day, then a further penalty, it may extend to rupees 1 lakh rupees for every day after the first day during which such failure continues. All right, so if the failure is a quantifiable one that we can calculate that this is the amount of default that has occurred, right? Then the penalty can be 1 crore rupees on the company as well as the officers, or twice, two times the amount which is involved in such failure, plus if it is of a continuing nature then rupees 1 lakh. So this is a very, we will say, enhanced amount of penalty as compared to the provisions before the amendment that was made in 2016, and this penalty will be imposed by the adjudicating authority, which is the officer or committee of officers of the Reserve Bank. So for this, the adjudicating authority will first serve a notice on the ARC or the person who is involved in the default that they should tell that why the amount which is specified in the notice, or why the amount of penalty which is specified in the notice should not be served. They should be given a reason or opportunity to be heard, right? Before taking the final decision, a notice will be sent to them, and the adjudicating authority will give them an opportunity to explain that if the complaint that has been made is a misappropriation or due to human error or anything, so they'll be given a chance to stand their ground to give their explanations. Then if any penalty is imposed, then it will be payable under, or within how many days? It will be paid within 30 days. Whenever the penalty is finalized by the adjudicating authority, they will have to, after the notice has been sent, they will have to pay it within 30 days. And if they do not pay the penalty within the specified period, then RBI can also cancel their registration, that we saw in the previous session. The cancellation of the registration if there is non-compliance to the directions of the RBI or provisions of the Act. So if they do not pay the penalty, then the registration of the ARC will be cancelled. And again, enough opportunity will be provided to the ARC to be heard, right? So these are the provisions which are made for the penalty. And other things that we have seen, the written complaint made by the officer of the registry or the officer of RBI, and then the adjudicating authority will decide how much penalty will be imposed or what imprisonment term will be given. All of these things are there. Again, the power of the appellant authority is also there. The aggrieved individuals, the aggrieved persons, either the ARC or the officers of the ARC of the company, they can file a further appeal to the appellant authority, the appellate authority, right? They will, when they receive the application, the complaint, after payment of the fees, they will take on the consideration and then they will give their final decision. Today we'll be covering the unit 17G. This chapter, basically we have the miscellaneous provisions under the SARFAESI Act. We have completed the important topics like the offences, the central registry, enforcement. In this, we'll be talking about the various cases in which the SARFAESI Act is not applicable, and is there any protection of action which is provided, which is done in good faith by the ARC or the secured creditor or the tribunals. Then offences by the companies, if any, how are they dealt with? All of these things we are going to discuss today. Again, this is very important from the exam point of view, so make sure that you like the video and you subscribe to the channel so that you don't miss any of the updates. So let us start with the unit. Okay. First, we have the non-applicability, the securities to which the SARFAESI Act is not applicable, or the securities which cannot be taken under reconstruction or securitization, which cannot be referred to the ARC by the creditor. So first, if a lien is created on any goods, I hope you remember we had discussed a lien, a pledge, a set off in the modes of charges chapter. So if a lien is created on any goods, money or security given by or under the Indian Contracts Act, or if it is a case of a sale of goods, so the Sale of Goods Act or any other law, then the SARFAESI Act is not applicable. If a pledge of movable goods is made under the Indian Contracts Act, if the creation of security interest is there in any vessel which is defined in the Merchant Shipping Act of 1958. Already the Merchant Shipping Act is excluded, and any conditional sale, a hire purchase or lease in which no security interest has been created. If the charge is not registered in the case of a mortgage by conditional sale or a hire purchase agreement or a lease, then also the creditor cannot get the security or the asset securitized. Under the SARFAESI Act, If there is any rights of the unpaid seller, then the security will be exempted. All the properties which are not liable for attachment, any security which is not exceeding rupees 1 lakh, where the interest for securing payment of any financial exceed is not exceeding 1 lakh rupees. So we had studied this, that for the applicability in the SARFAESI Act, minimum 1 lakh, which is now increased. Then security interest cannot be created on the agricultural land, or in which the amount due is less than 20% of the principal amount and the interest thereunder. So these are the securities which are excluded, on which the SARFAESI Act is not applicable. And section 31 is very important because it contains the details of all of these securities. Then, are any banks or financial institutions exempted to exercise their right under the SARFAESI Act? So yes, these financial institution or banks will be notified by the central government, and this notification will be made in the public interest in the official gazette. So the SARFAESI Act, its provisions shall not apply to any banks or the financial institutions which are notified by the central government, or this act will be applicable with exceptions, modifications, or adaptations that may be specified in the notification. And like we already said, this notification will be made by the government in the official gazette. It will be made in the official gazette. This copy of the notification, it shall be laid in a draft before each of the house of the parliament. So there's a whole process which has to be followed, and then for a total period of 30 days both the houses will discuss it, and the houses, they agree in disapproving the issue of notification, that shall not be issued. If they agree, then it will be issued, and again the copies have to be first laid in front of both the houses. So this will be the process, because it is a type of a notification, that is a type of law which is made by the government, so the parliament has to give its approval. Then if both the houses of the parliament, they agree, then the bank or the financial institution can be exempted from the provisions of the SARFAESI Act. Next provision is that the Reserve Bank or the Central Registry or any secured creditor or any of its officers are protected for the actions which are taken in good faith by the provisions made in the Act. For example, if the Central Registry takes the decision, or the RBI takes the decision of securitization, and whichever method or measure is followed, no person can initiate any suit, prosecution, or any other legal proceeding against the Reserve Bank, the Central Registry, or the secured creditor if the actions are in accordance with the provisions of the Act. So this protection is given so that the actions that are contemplated and authorized under the Act can be taken without the fear of counter action from the borrower or any other person who is having interest in the property. So when any action is taken or a decision is given by the Central Registry or the secured creditor regarding the securitization, and it is according to the provisions and the rules and regulations of the SARFAESI Act, then no counter action can be taken against them. Right. Then if any company or its officers, they commit any offense under the provisions of the SARFAESI Act, then they are punishable. Why? Because the provisions of the Act are statutory obligations. They cast some statutory obligations which have to be followed by the companies. So if any company, any offense is committed under the provisions of the Act by a company, as well as any person who is in charge of the business of the company, then they are deemed to be guilty of the offense and they're liable to be prosecuted and punished. So not only the company, but the directors or any employee of the company, if they're involved in the offense, they will also be liable. However, it is permissible for a person acting for the company to prove that the offense was committed without their knowledge, or they had exercised due diligence to prevent the commission of such offense. If they prove their stand, then the concerned person will not be punishable. Otherwise, the person involved is also punishable, they are also liable. Also, if such offense is committed with the consent of any director or officer of the company, then the director or the officer shall also be deemed to be guilty of the offenses along with the company, right? So all the categories of borrowers, such as individuals, partnership firms, companies that are incorporated under the Companies Act, the penal provisions are applicable to all of these categories. All right. Then if we talk about the jurisdiction of civil code, so it is stated very clearly that the SARFAESI Act has conferred jurisdiction to the DRT and the DRAT only, the Debt Recovery Tribunal and the DRAT, Debt Recovery Appellate Tribunal only. Therefore, for any matters where the empowerment and jurisdiction is vested with the DRT or the DRAT, no civil court shall have the jurisdiction to entertain any suit or proceeding relating to those matters. So when in a particular area the DRT has been established, so automatically it is deemed that all of the eligible cases will be taken by the DRT only, and no person can raise any appeal against the decisions of the DRT with the civil code. All right. So this is also given under the Recovery of Debts Due to the Banks and Financial Institutions Act 1993. That is the next chapter and we will be studying that as well. Right. So wherever the DRT has been established, so no civil court shall have the jurisdiction to entertain any suit or any proceedings relating to those matters related to the debt recovery. So there's a bar on the civil court on the jurisdiction. All right. Then it is also stated that the provisions of the act have overriding effect or any other laws if the provisions in the other law are not consistent with the act, right? For example, such inconsistencies are in the Transfer of Property Act. So the SARFAESI Act will apply, overriding the provisions of those act. This is given in section 35. Also, there is the limitation which has been stated, the limitation, the time period. So any action can be taken or the secured creditor can take against the security under the SARFAESI Act. This has to be taken within the limitation period which is prescribed by the provisions of the Limitation Act. So within 3 years or 12 years, whatever the case may be, right? So the claim within the period of limitation has to be made, and it will be necessary for the banks and the financial institutions to comply with the limitation aspect, right? If, however, after the sale of the securities, the claim is not fully satisfied and there are dues remaining which have to be recovered from the borrower, then the creditor will file a civil suit before the civil court or a claim before the DRT, again within the limitation period. To avoid such situations, the secured creditor should make an assessment before taking the possession of the security, whether it would be possible to sell the security and make an eventual claim for the shortfall within the limitation period. So this is regarding the limitation. Also, the power to make rules is given to the central government. We had already seen the process that any rule which has to be made or a new amendment has to be enacted. For that, the parliament, both the houses of the parliament have to agree. So for carrying out the provisions of the act, the central government can frame rules and then notify them in the official gazette. Also, with the Information and Technology Act of 2000, it allows the government to notify the rules in the electronic gazette also, that is on the website of the government. So this is also important. Whenever a rule is made by the government, again, let us repeat the process. The rule is to be required to be kept before both the houses of the parliament, and while in session for a total period of 30 days, both the houses should agree to the rules that are framed, and then they can make modifications or they can decide not to enact the rules, the rule will get the validity in the manner which is decided by both the houses. All right. So this is the whole process, and once the rule is decided to be made, then it has to be notified in the official gazette in the public notice. It is deemed to be have gotten the public notice. And with the Information Technology Act, through the electronic gazette also, the notification can be made, that is on the website of the government. All right, so these are all the important provisions of the SARFAESI Act that are given under this chapter. There are certain amendments and other enactments that have been made for the provisions. So when questions are asked from this unit, it can be like the provisions of SARFAESI Act are applicable to which of the following. So you will be given options like pledged goods or only mortgaged properties, securities that are not charged to the creditors, securities which are charged to the creditor but not in possession of the creditor. So you need to know where the SARFAESI Act is not applicable. Simply you can answer that the provisions of the SARFAESI Act out of these will be applicable only to the securities which are charged to the creditors, right? Also, for example, let us say regarding the rules that are framed by the central government, when do they get valid? So you'll be given several options like after the appellate tribunal approves them, or the Supreme Court approves them, or when the government notifies the same. And then one option will be when both the houses of the parliament approve the rule. So you know that the procedure is followed in the parliament. So both the houses of the parliament have to approve the rule. Such questions can be asked from this particular unit. All right. The unit 17H from module C. So let us start with this unit, which is the registration of security interest by the secured creditors and other creditors or rectification by the central government. So when we talk about registration of security, so under this act, the section 28 has made it compulsory for the security interest to be registered with the central registry. If a bank, they want to enforce their rights under the SARFAESI Act, first they have to get the charge registered. If the charge is not registered, then they cannot enforce the act, and they have to get it registered with the central registry. So whenever a charge is created on a loan that is taken by the borrower, it is compulsory that within the stipulated time period the charge should be registered either by the borrower, or if the borrower doesn't, then the bank by paying off the fee which will be recoverable. All of these provisions we have already seen. Also, the section 26E says that whenever the security interest is enforced, then the debts due to any secured creditor shall be paid in priority. So whenever the security interest is enforced under the act and the property is, let's say, sold in the market and recovered, then what will happen? Whatever money that is generated will be first used to pay off the debts that are due to the secured creditor. Any unsecured creditor or any third party, they cannot claim a right over it. Also, priority will be over and above all the debts and all the revenues, taxes, cesses and other rates that are payable to the central government, state government or the local authority as well. So this is regarding the compulsion for the registration of the security interest for the act to get enforced. Then we have this registration by the secured creditors. So the provisions of the chapter 4 relating to the central registry, the central government may extend these provisions. So for not just the registration of charges but also for the creation, modification and satisfaction of any security interest over any property of the borrower will also be registered with the central registry. For the purpose for the securing due prepayment, whenever any property, the security interest is created, for the creation, modification and satisfaction, everything will be registered with the central registry. And for this, The various forms are there in the format of CHG, which we have already seen. Then, from the date of notification, any creditor, including the secured creditor, may file the particulars of the transaction of the creation, modification, or satisfaction with the central registry in the form and manner as may be prescribed. So, we had discussed earlier also that if the borrower does not get the charge registered, it is the responsibility of the creditor to get it registered with the central registry, and this will be in the form and manner that may be prescribed. Then the SARFAESI Act also says that all the powers for the rectification in any charge that is created is given to the central government. So not the DRT, the DRAT or any other officer, but the central government has the power to rectify and set right the omissions, errors in filing of creation, modification, or satisfaction of charges, and mandatorily these will be required to be carried out. So, this provision is also there. So, we talk about the rectification. Let's say there's an omission in the charge that is created in any of the particulars of any transaction of securitization, asset reconstruction, of security interest or modification with respect to anything that is made under the charge, if it was accidental or due to inadvertence or some other sufficient cause, then it will be corrected, right? That if the central government is satisfied with it. On other grounds, it is just and equitable to grant relief also if caused any monetary loss on the application of the secured creditor or the ARC or any other person interested on such terms and conditions. Then the central government can direct the time for filing of the particulars of the transaction. Also, where the central government it extends the time for the registration of the transaction of security interest or securitization or asset reconstruction, the order shall not prejudice any rights that are acquired in respect of the property concerned or the financial asset before the transaction is actually registered. All right, so before the transaction actually gets registered, this extension of time given by the central government will not hamper the rights that are acquired in respect of the property. All right, so this is also there in the rectification provision. So the right of enforcement of the securities and priority we have discussed will be given to the secured creditor. The registration by the secured creditors and other creditors is also given for the modification, satisfaction. Also, every authority or officer of the central government that is interested with the function of recovery of tax or other government dues or any for issuing any other attachment, they will know that first the priority will be given to the secured creditor. Then if any person who is having a claim against any borrower, they have to and they have obtained the orders of attachment of property from the court or other authority, such person may file the particulars of such attachment again with the central registry. Also, they will pay the payment. They will pay any fee that may be prescribed. So this is regarding the registration by secured creditors. Then we have the effect of registration of transaction. When the transaction is registered, what will happen? So there's a legal impact of registration of a charge with the central registry, which is given in the section 26C of the Act. It states that without prejudice to the provisions that are contained in any law for the time being in force, if there is any registration of the transactions of creation, modification, or satisfaction of security interest by a secured creditor or other creditor or filing of attachment orders, then this charter shall be deemed to constitute a public notice from the date and time of filing of particulars. So whenever a charge is registered, it is deemed that the public now has the notice that the security interest has been created, the charge has been registered on the property. So whenever such transaction is registered with the central registry, then it will be deemed to constitute a public notice. And if any other creditor, they give out loan on the same property, it will be their fault. So it is their responsibility to go on the site and check whether it is unencumbered or not. So where the security interest or the attachment order upon any property in favor of the secured creditor or any other creditor are filed for the purpose of registration, the claim of the secured creditor shall have the priority over any subsequent security interest. Again, if the property, let's say a house, was kept as a security with Bank A and the loan was availed by any person X, and Bank A has gotten the charge registered. They got the charge registered with the central registry. Then even if Mr. X goes to another bank, Bank B, with the same property and gets a loans again that, then also the Bank B will not get priority. Why? Because Bank A has already gotten the charge registered. In the case Mr. X defaults and the SARFAESI Act provisions are used, then the first priority will always be with the secured creditor who first got the charge registered. If let's say Bank A had not registered the charge, they had given out the loan but they had not registered the charge, and this charge was registered by Bank B. Bank B, who was the second bank who gave out the loan on the same property, but the charge was registered first by Bank B, then the priority will now be given to this second bank. So if we talk about the priority, it will always be given to that creditor or the secured creditor that gets the charge registered. So it doesn't matter the sequence of giving out of loan, but the registration of charge. So the priority will always be given to the secured creditor. And with this particular part of this chapter of the SARFAESI Act, we have completed the SARFAESI Act. We talked about the SARFAESI Act, how it was enforced, the various definitions, the regulation of securitization and reconstruction, the enforcement of security interest, the central registry, the offences and penalties, everything we have discussed, and we have now completed the SARFAESI Act. Now you have the complete understanding of this particular act. Starting tomorrow, we'll be starting a new chapter, which is the Recovery of Debts and the Bankruptcy Act of 1993. Again, a lengthy chapter, but more or less you will see that the provisions are same under the SARFAESI and the Recovery of Debts and Bankruptcy Act, which is also known as the DRT Act. We are going to start with a new unit from Module C, which is the Recovery of Debts and the Bankruptcy Act of 1993, which is commonly also known as the DRT Act. So when we talk about the DRT Act, basically before the enactment of this act, the banks had to resort to the civil courts for the resolution of their debts, and this took a lot of time. So what the government of India did, they launched or they enacted this act, the Recovery of Debts Act, and it was challenged by the validity of the act was challenged by the Delhi High Court Bar Association, right? It was challenged by the Delhi High Court Bar Association, which decided that the law was unconstitutional and it was void and hit by the Article 14 of the Constitution. Later on, it was taken to the Supreme Court that decided that yes, special courts are important for the faster recovery of the dues to the banks, for the recovery so that the banks can function well, for the financial status of the nation and the financial health. Then the constitutional validity was given to this act and special courts were set up that were going to deal only with the recovery of dues to the banks, right? Amendment was also made and the name of the act was changed to include bankruptcy. This amendment was made in 1993. So earlier, the name of the act was the Recovery of Debts Due to Banks and Financial Institution Act, and in 2019 the name was changed to the Recovery of Debts and Bankruptcy Act to also cater to the insolvency resolution and bankruptcy of individuals as well as the partnership firms. So in this particular unit we are going to see this introduction in the formal terms. So in 1991 the Recovery of Debts Due to Banks and Financial Institutions Act 1993 was passed, and it came into operation from 24 June 1993. The Act constituted the special DRTs for the speedy recovery of the unpaid dues of the banks, and later on in 2019 with an amendment the name was changed to the Recovery of Debts and Bankruptcy Act of 1993 to cater to the insolvency resolution and bankruptcy. So starting from the introduction of the act, the passing of the act by the government, the questioning of the constitutional validity by the High Court, and the Supreme Court finally giving its the constitutional validity. This act is a very important milestone for the banks and the financial health of the nation. So the constitutional validity of the act was challenged by the Delhi High Court Bar Association before the Delhi High Court, and the Delhi High Court decided the law to be unconstitutional, void and hit by Article 14, which is a fundamental right under the constitution. So the Delhi High Court decided against the act. They said that the law or the courts that are already working in the nation, the civil courts who are directly under the control and superintendence of the high courts, they have been deprived of their jurisdiction, and therefore it is against the theme of the constitution and independence of the judiciary. This was the reason given by the Delhi High Court stating that the act is void and it is against the Article 14. Then an appeal in the Union of India versus the Delhi High Court Bar Association, the Supreme Court decided in favor of the Union of India and declared the status to be constitutionally valid. So Supreme Court took this decision that the act is constitutionally valid, and for the speedy recovery of the dues to the banks, it is important that special courts be set up. So the Supreme Court observed that the Parliament alone can enact a law in regard to the banking business, and it also includes the recovery of banks' dues, and for that purpose setting up of adjudicatory body like the banking tribunal is valid. So the Supreme Court gave its agreement to the DRT and the DRAT for the recovery of bank dues. So this is regarding the constitutional validity of the act. Then if we talk about the extent and commencement of the act, so the act is applicable to whole of India, and for the commencement it is stated that the provisions of the act shall not apply where the amount of debt due to any bank or any financial institution is less than 10 lakh rupees. So if wherever the debt that is due to bank or a group of financial institutions that are joining in an application, if it is less than 10 lakh rupees, then it will not be accepted by the DRT for resolution. Later on, this limit has been increased from 10 lakhs to 20 lakhs. So now, for a case to be taken under the DRT Act, the unpaid due should be minimum 20 lakh rupees, right? Then there are some important definitions under the act. The important definitions are the appellate tribunal, which is the DRAT. It is the body established for the purpose of preferring an appeal against the order passed by the tribunal. So the bank, when they had unpaid due of 20 lakh rupees, they raised this issue with the DRT. The DRT under whose jurisdiction, this is very important, under whose jurisdiction the bank was operating. right? So this case was referred to the DRT, and the DRT took its decision against the defendant, and the defendant was aggrieved by the order taken or the award given by the DRT. So this defendant now has the right to file an appeal before the DRAT. Within a specified time period, they have to file this appeal. Also, first they need to make a certain percent payment of the award that is given, then only they can file the appeal. All of these things are there that we will be seeing in the further provisions. All right, so the application can be made. Application means the application which is made to a tribunal for the recovery of debt, and appointed day. Now appointed day is a term that we have studied in the MSMED Act, but it is completely different from the definition of appointed day here in the DRT Act. So in the MSMED Act, it was when the payment had to be made to the MSME seller, right? In this particular act, the appointed day is related to the tribunal or an appellate tribunal. So when on the date on which such tribunal established is known as the appointed day. Not when the act came into force, but when in a particular area a tribunal is set up and the jurisdiction is decided and the presiding officer is decided, then it is known as the appointed day when a tribunal is set up. Then chairperson is going to be the person who is going to chair the appellate tribunal. So the highest officer of the appellate tribunal is going to be the chairperson, right? So it is also important for the faster recovery of debts to define the debt, also to decide the jurisdiction of the tribunal under the DRT Act. So if any person or a pooled investment vehicle, any law that is being enforced, any special law, or a debt which is legally recoverable, everything will be covered under the definition of a debt when we are talking about the DRT and its jurisdiction. So a debt that is due to the banks and financial institution. Also, if we talk about the jurisdiction, so where the particular default has occurred will be the jurisdiction of the DRT, right? Then we have the presiding officer who is going to be the highest officer of the DRT. So DRAT has its chairman that will be appointed according to the eligibility conditions and the tenure. The DRT is going to have its presiding officer. The presiding officer. Then the recovery officer means a officer which is appointed by the central government for each tribunal under the subsection 1. And these officers are appointed under the act for implementing the recovery orders that are passed by the tribunal. So like we had studied in the SARFAESI Act, the officers are appointed by the central government. They should meet the eligibility criteria, like the eligibility criteria for the chairperson, the qualification for being appointed as the presiding officer, and the term. So the presiding officer, for example, they should be qualified to be appointed as a district judge, and the term that for which they will be appointed will be 5 years or until they attain the age of 65 years, whichever is earlier. Similarly, when we talk about the qualification for the chairperson of the appellate tribunal, then they should be qualified to be a judge of the high court. Apart from that, they should be a member of the Indian legal service, and tenure will be 5 years or until they attain the age of 70 years. Plus, they should also have held office as the presiding officer of a tribunal for at least 3 years. All of these qualifications, tenures, we will be studying in the next provisions, in the next part of the DRT Act. All right. So it is very important that you understand why the DRT Act was brought into force. Then the debt recoverable, we said it is 20 lakh rupees. Now, is it important that the debt recoverable through the DRT? Should it be secured or unsecured? Like for the SARFAESI Act, we stated that the debt recoverable should be secured. Only then the rights of SARFAESI can be used. But in the case of the DRT Act, the debt recoverable through the DRT, it may be secured or unsecured. Both the cases will be taken, right? Then which types of debts will be recoverable under the DRT Act is important. Also, if a civil court had, let's say, passed a decree, then before the establishment of a recovery tribunal, will this order be held valid or not after a tribunal is established in the particular jurisdiction? So all of these things are important. All right. And today we are going to discuss the unit 18B from module C. So we are discussing the under the DRT Act, the establishment of tribunal, appellate tribunal. So whenever the banks or any financial creditor, they want to exercise their rights of debt recovery under the DRT Act, they can refer to the debt recovery tribunal or the debt recovery appellate tribunal, wherein the highest officers will be the presiding officer and the chairperson respectively. So who has the right to establish the tribunal? Who decides the jurisdiction? Who has the power to decide the jurisdiction? Then the appointment as the presiding officer. What is the qualification and the tenure? The qualification and tenure of the chairperson of the appellate tribunal. So let us begin with today's session. All right. First, when we are talking about the tribunals, we have already discussed the DRTs and the DRATs, the definitions of these tribunals, the definitions of the presiding officer and the chairperson. So, who has the power to establish the tribunal? It is with the central government. So, the central government is empowered to establish one or more tribunal to be known as the Debt Recovery Tribunal to exercise its jurisdiction, powers, and authority. So, if in a particular area any unpaid dues arise or the banks they want to file an application, they need to see in which DRT's jurisdiction they fall. Okay. Also, the central government can decide and specify the areas within which the tribunal may exercise its jurisdiction for entertaining and deciding the applications. We have already seen wherever the tribunals are in force, they are established, only they are going to deal with these cases of recovery. So the civil courts will no longer have jurisdiction or right to intervene. And whenever the government decides to exercise these powers, take decisions of establishing one or more tribunals or increasing or decreasing their jurisdiction, they have to notify it in the official gazette of the government, and it will deemed to have public notice. It will be deemed to have public notice. All right. Then if we talk about the composition of the tribunal, so the tribunal is made up of only one person, which is known as the presiding officer. The presiding officer who is going to accept the application, they will see the application is submitted by the creditor in the right manner, providing all the documents and information that is required. And the appointment, as we have already seen, is done by the central government by issuing a notification in the official gazette, right? Also, if let's say the central government they decide that a tribunal 1 in a particular area under its jurisdiction is working with a presiding officer, and a tribunal 2 is working in their area with another presiding officer, but for some reason, let's say the presiding officer of the tribunal 2 is absent temporarily. So the central government can also authorize the presiding officer of one tribunal to discharge the functions of the presiding officer of another tribunal. So who has the right to take this decision? Again, it is vested with the central government. So the presiding officer will take on the functions. All right, there can be other reasons also. So if the central government is satisfied, then they are going to authorize the presiding officer of one tribunal to discharge the functions of the presiding officer of another tribunal also, or they can also be a common presiding officer for both these tribunals. All right. Then if we talk about the qualification of the presiding officer, we have already seen that the appointment will be done by the central government, but there's an eligibility criteria. For an entity to be eligible to be appointed or qualified to be appointed as a presiding officer, they should have been, or they should be at least qualified to be appointed as a district judge. So a person is qualified for the appointment as presiding officer of a DRT if they have been, if they or they are, or they are at least qualified to be appointed as a district judge. Even acting district judges can be appointed as the presiding officer. But the presiding officer of a tribunal, when they're appointed, they're going to hold the office for a term of 5 years from the date on which they enter upon the office, or till or until they attain the age of 65 years, whichever is earlier. So we talk about the tenure and the qualification. Qualification is that of a district judge. Tenure is either 5 years of office term or 65 years of age, whichever is earlier. Whichever is earlier. So if you're making your own notes, make sure that you make these types of notes: the presiding officer, qualification, and tenure. Right. Then we have the establishment of the appellate tribunal for hearing of the appeals passed for appeals against the orders of the DRT. We'll be seeing the procedure for filing the appeal, in how many days the appeal should be filed. Is there a certain amount of the award that has to be paid before filing the appeal? These are there in the next few chapters. So if we talk about the establishment, so again the central government is empowered to establish one or more appellate tribunals, and these will be known as the debt recovery appellate tribunal. They are going to exercise the jurisdiction, powers, and authority. Again, the similar provisions are there. The central government is also empowered to decide and specify the areas within which the tribunal may exercise, and these decisions have to be notified in the official gazette, right? Also, the officer of the appellate tribunal here will be known as the chairperson, and the appointment shall be done by the central government. So the person who is going to oversee the tribunal, the DRT, is the presiding officer, and the person who is going to oversee the appellate tribunal hearing of the appeals is known as the chairperson of the DRAT. The chairperson of the DRAT. Then if we talk about the qualification of the chairperson of the DRAT, so as per section 10 of the Act, a person shall not be qualified for the appointment of the chairperson of an appellate tribunal unless, so this is given in a negative sense, but what we mean is that the minimum qualification of any person to be appointed as a chairperson is that they are they have been in the past, or they are at least qualified to be a judge of the high court. So first, if we talk about the qualification of the chairperson, so the judge of high court, then they should have been a member of the Indian legal service and held a post of grade of that service for at least 3 years. So member of the Indian legal service for 3 years, or, and we are referring it as or they have held the office of the presiding officer for at least 3 years. So qualified to be a judge of high court, then member of the Indian legal service for 3 years, or they have held the position of a presiding officer of a DRT for at least 3 years. So this is a conditional. Compulsory is the judge of high court, conditional Indian legal service or the presiding officer for at least 3 years. This is the qualification. And then for the tenure, they are going to hold the office for a term of 5 years from the date of commencement of their service, or until they attain the age of 70 years. So this is a difference in their tenure. Both in terms of the term of office, the presiding officer and the chairman are going to hold the office for a term of 5 years. But if we talk about their age, so the maximum age for which they can keep the office, they can hold the office, for the presiding officer it is 65 years, and for the chairperson of the DRAT it is 70 years, whichever is earlier, right? Also, there are provisions related to the vacancy, the staff of the tribunal. So, the staff, one or more recovery officers will again be provided by the central government or other officers and employees of the government, and they will be under the superintendence of the presiding officer for the DRT. Then, if there are any vacancies at the tribunal or the appellate tribunal, so if there occurs any vacancy that is not of a temporary nature, that is the person has resigned, the presiding officer has resigned from their post, or they have been removed from their post, right? So what will happen here? The appointments will again be made by the central government. And when such appointments are made, this is to be made very clear that the proceedings that were going on before the earlier presiding officer of the tribunal or the chairperson of the appellate tribunal, they are going to continue from the stage where they were left. So when the presiding officer or the chairperson, they vacate their office, or their position for a permanent nature, not a temporary but a permanent reason, then the new presiding officer or chairperson will be appointed by the central government, and they are going to start from the stage where the proceedings had been left. The same stage. Fresh proceedings will not begin. This is regarding the vacancies. If we then talk about the finality of the orders, constituting the tribunal or the appellate tribunal. So when the central government is appointing any person as the presiding officer of the DRT or the chairperson of the DRAT, then it shall not be called in question in any manner. So no decision of the central government can be called in question in any manner. So the decision of the central government in the appointment of the presiding officer or the chairperson, it cannot be questioned. Similarly, the order, if any order is passed by the DRT or the DRAT, that act or the proceeding can also not be questioned in any manner. So no act or proceeding before the DRT or the DRAT can be questioned merely on any defect in the constitution of a tribunal or the appellate tribunal. So this is regarding the finality of the order. So the order of the government or order of the DRT and the DRAT are considered final. Finally, if we are talking about the vacating of the post by the presiding officer, so the presiding officer or the chairperson, they can resign by giving a notice of 3 months. So they can, by a written notice of 3 months, resign their office. And if the presiding officer of a tribunal has to be removed, then it will be removed only by an order of the central government and on the ground of proved misbehavior or incapacity. So if the chairperson of the DRAT, they find that the presiding officer is engaged in some misbehavior or incapacity in taking decisions or giving their orders, they are going to make a written notice detailing all the information regarding the occurrence of the misbehavior or incapacity. They will furnish this to the central government, and the final decision will be taken by the central government. Again, regarding the removal of the presiding officer, we have the provisions in detail that we are going to discuss in the further units. All right. Today we have the Unit 18C from Module C, which is Jurisdiction, Powers and Authority of the Tribunal. So we are covering the DRT Act, and today we are going to discuss about the tribunals, the DRTs and the DRATs. What are their jurisdiction? what powers are given to the, let's say, the chairperson of the DRAT regarding the meetings, regarding the scrutiny and inspection of the presiding officers, and is there any bar of jurisdiction on civil courts on the matters assigned to the tribunals in a particular area. So before we start with this session, make sure that you like and share this video and also subscribe to the channel, because all of these videos that we are covering today, all of these sessions are very important for your exam. So let us begin. Right. So first we have the jurisdiction of a tribunal. In yesterday's session, we discussed that a tribunal is the central government is empowered to decide the jurisdiction of a tribunal, to appoint the presiding officer of a DRT, as well as the chairperson of the DRAT, right? And in the very first session, we discussed about the definition of appointed day. The day from which they function is declared in the notification. The day from which the appellate tribunal starts functioning is known as the appointed day. From that day, they exercise their jurisdiction, powers, and authority to entertain and decide the applications or appeals from the banks and the financial institutions. This is also for deciding the applications under the IBC code, which is the next chapter. We'll be studying the IBC code. So the jurisdiction starts from the appointed day of the tribunal. First important point. Second point is that the coverage or the jurisdiction of the tribunal is for only those cases where the claim for the recovery of the debt must be rupees 20 lakhs and above, including the principal and interest. So where the cases where the debt is not 20 lakhs, those cases will not be heard or dealt by the DRT. They will go under the Lok Adalats or any other case as per the law, right? So for the cases to be heard or accepted in the DRT, they should be rupees 20 lakh and above. Then a very important case is mentioned here in the Bank of India versus the Harshad Rai Odhavji Modi. A very, very popular case. The Bombay High Court had held that an application for the execution of decree of foreign court can be entertained by the DRT. So even if a decree was given by a foreign court, then also it will be entertained by the DRT. So this decision was given in which case? So this was given by the Bombay High Court in the Bank of India versus the Odhavji Modi case, right? Then if we talk about the power of tribunal, more so about the power of the appellate tribunal, the DRAT, or its chairperson. So we have discussed that the only officer or the DRAT consists of only one person, which is the chairperson, appointed by the central government. And the qualifications, if you remember, we discussed that they should be eligible, they have been or they are a judge of high court, then Indian legal service, member of the Indian legal service for 3 years, or they have performed the duties or they have been in the post of a presiding officer of any tribunal for 3 years. So these are the qualifications of the chairperson of appellate tribunal. If we talk about the qualification of the presiding officer, then the judge of a district court, right? So the chairperson of the appellate tribunal is given the general power of superintendence and control over the tribunals under their jurisdiction. So the tribunals that are under the supervision and control of the appellate tribunals, the DRTs under the DRATs, they are they are supervised by the chairperson. So, what all powers are given to the chairperson? They can transfer any application from any presiding officer within their jurisdiction to any other presiding officer on receiving the application of transfer of the case or even on their own motion. So, if the central government or any other authority, they give a notice that this case should be transferred to another presiding officer for any reason, or they themselves feel that yes, if we transfer this case to another presiding officer, it will be beneficial for the faster recovery, they can do so. So this power is given to the chairperson of the DRT. But before such transfer, they have to give notice to all the parties that are involved and hear them. They are also given the power to appraise the work of presiding officer. So in yesterday's session, we discussed that the presiding officer, they can terminate, they can leave their office e- either by giving a resignation with 3 months notice, or they can be removed by the central government on an application that is filed by the presiding officer, stating the reason of why the presiding officer should be removed and the reasons only on proved misbehavior or incapacity. So this here, the chairperson of the appellate authority, they will appraise the work of the presiding officer, and they will then recommend the central government to remove the presiding officer from their post if there is any misbehavior or misconduct or incapacity, right? Other things for the general powers and superintendence and control over the tribunals. So they can direct the tribunal to furnish any information relating to the pending cases, both under this act and the SARFAESI or any other law for the time being in force, the number of cases that are disposed of by the tribunal, the number of new cases that are filed, or any other information that may be considered necessary by the chairperson. So the chairperson can direct the presiding officer, the tribunals under their jurisdiction, to provide to furnish information related to the pending cases, the cases disposed, the new cases filed, or any other information. So they have this power. Also, they can convene the meetings of the presiding officers of the tribunals periodically to review their performance. If during their review whereon assessment of the performance of any presiding officer of the tribunal, the chairperson finds that an inquiry is required to be initiated against the presiding officer for two reasons: either misbehavior or incapacity to provide solutions or to solve any case, then the chairperson shall submit a report to the central government recommending action against such presiding officer. So this report will be submitted by the chairperson to the central government. Very clear, we should make it very clear in our minds that the chairperson cannot remove the presiding officer. They will only conduct the inquiry, they will prepare a report. In writing, they will mention the reasons why the presiding officer should be removed, the misbehavior or incapacity, the date and time, the case, everything, every detail. And they will submit that report to the central government in writing, and then the final decision of the removal will be taken by the central government. So the inquiry is conducted by the chairperson, but the removal is done by the central government. Also, from the date of establishing the tribunal, that is the appointed day, where in an area the tribunal DRT has been established, from that day onwards, no court or any other authority shall have any jurisdiction, power, or authority to deal with cases, that is the claims of banks and financial institutions for the recovery of 20 lakhs and above. So if a tribunal has been established by the central government at a place, in an area, in a district, wherever, there the civil courts, they can hear no cases. All of these cases of the claims of banks for the recovery of dues of 20 lakhs and above will go to the tribunals now. So the civil courts or any other authority will lose their jurisdiction where the due amount recoverable is 20 lakhs, but this is not applicable to the high courts and supreme courts exercising their jurisdiction under Article 226 and 227. These are the writ jurisdiction. The writ jurisdiction. If the DRT gives the order of detaining the defendant or any person, keeping them in custody, and this keeping of the defendant in custody is against the fundamental right of the individual, then a writ can be passed in the High Court and the person will have to be released. The writs are the mandamus, quo warranto, but again, not in our syllabus. We'll be seeing them in the next session that what are these writs, how the High Court and the Supreme Court they practice or they exercise their jurisdiction under the writs of the Constitution. Still, apart from those exceptional cases, the civil court or any other authority will have no jurisdiction for the cases of the amount recoverable 20 lakh and above where the DRT has been established, right? Also, it means that apart from the writ jurisdiction, no claim for the recovery of the amount can be filed before the High Court. Apart from the writ jurisdictions, no person can go to the High Court, right? And this will be when the from the jurisdiction of the DRT, not from the date when the act came into application. So when the tribunal is established having jurisdiction in the particular area, from that day onwards, all the cases will go to the DRT and this jurisdiction will not start, or the bar of jurisdiction on civil courts will not start when the act came into force. So very important that you remember this point. Only from the date of appointment of the tribunal, all the cases will now go to the DRT. If, however, let's say the DRT in a particular area was established in the year 1996, let's say June 1996, right? But before that, a civil court having its jurisdiction in the same area, they had given its decision on a particular case. Let's say they had given this decision in April April 1996. Then what will happen? Then what will happen? This will mean that prior to the establishment of the tribunal, but after the commencement of the DRT Act, the order passed by the civil court was well within the jurisdiction of the civil court. So, although the act was already passed, still the DRT was not established in that area, and the civil court had given their decision. So, that decision given by the civil court will be held valid in all cases. It will be held valid. So this decision was given in the Bhanu Construction Company Limited versus Andhra Bank, where the question was the order passed by a civil court after coming into force of the DRT Act, but before establishing. So a question can be formed in the way of a case study that a decision was taken by the civil court after the act was passed, but a DRT was not here established. Then can the order be questioned, or can the case be now taken to the DRT again for fresh proceedings? So, no. The order will be held valid because the appointed date of the DRT was in June 1996 and the decision was taken by the civil court in April 1996. Unit 18D, which is Procedure of Tribunals. So, this particular chapter, we are going to talk about how can an application be made to the tribunal, how the appeal to the appellate tribunal is made, what is the deposit of the amount of debt due for filing the appeal with the DRAT, what are the procedure and the powers of the tribunal, and the limitation or the time period for filing the application or appeal. So let us start. First, we have the application. So when a bank or a financial institution, they have to recover any debt from any person or entity, then they have to make an application to the tribunal within whose local limits the tribunal or the institution is working. So every tribunal's local limits or jurisdiction is decided by the central government. Accordingly, the financial institution or the bank has to file the application with the DRT, right? So what will be the next step? The next step will be the tribunal shall issue the summons to show cause within 30 days of the service as to why the relief prayed should not be granted. Then direct the defendant to disclose the particulars of the properties other than the properties and the assets which are already specified. The other properties and assets should also be provided the information related to them to restrain the defendant from dealing with or disposing. So now from the date the order is passed by the tribunal, the defendant now cannot sell off or transfer the property to another person. right? So the branch or any office of the bank or financial institution, that the place where it is maintaining an account in which the debt claimed is outstanding. This is going to decide the jurisdiction of the tribunal, right? And then the summons will be made. Okay. Also, the defendant can now not deal with the property under consideration. Okay. Then the next step will be within a period of 30 days. The defendant has to present a written statement of their defense. So the defendant will be given an opportunity to be heard. They'll be given a period of 30 days if they want to claim, they want to set off or a counter claim, and such written statement shall be accompanied with the original documents or the true copies with the leave of the tribunal. So if the defendant they wants to file a counter claim or a set off against the complaint that has been made by the bank or the financial institution, for that 30 days will be provided. If, however, the defendant they fail to file the written statement within this said period of 30 days, then in exceptional cases or in special circumstances, an extended period will be provided, but this extending period shall not be more than 15 days to make the written application or written statement, right? Then if the written statement has been made and then the tribunal finds that it is just and convenient, then they can appoint a receiver of any property, whether before or grant of certificate of the recovery of debt. They can remove any person from the custody or possession of the property. Now here the tribunal, after hearing both the parties, after seeing the terms that are referred to by the complainant and the defendant, the tribunal is now giving the order to appoint a receiver, to remove any person from the custody, to give the possession, custody, or management of the property to the receiver, or confer the powers to the receiver which are required for their possession for bringing suits or defendant. So the filing of application, collection of rents and profits, preservation, realization, management, protection, execution of documents, whatever powers the tribunal they deem fit should be provided to the receiver will be granted. Also, they will appoint a commissioner for the preparation of an inventory of the properties of the defendant. So the defendant does have the right of pleading a set off, but after all of that, the next step will be the order which is given by the tribunal. All right. So they have the power to pass the interim orders, the attachment orders, and so on. We have already discussed in the previous chapters. Okay. Then, if we talk about the appeal to the appellate tribunal, when the DRT they have given an order of the recovery certificate, and the defendant or any person who is aggrieved by the order that is passed by the DRT, then they may prefer an appeal to the appellate tribunal or the DRT, which again has jurisdiction in the matter. But if the order was made by the tribunal with the consent of both the parties, then no appeal shall lie. This is very important. If the order was made by the DRT with the consent of the parties, then no further appeal shall lie. Then this appeal is to be required to be filed within 30 days from the date on which the copy of the order is received, and it will be accompanied by any fee that is prescribed. And the appeal filed after 30 days will be entertained by the appellate tribunal if it is satisfied about the cause for not filing the appeal in time, right? Okay. Then when the appellate tribunal receives the appeal, they will give a chance or opportunity to be heard to both the parties, and then they will confirm or modify or set aside the order which is passed by the DRT. So the appeal that is filed before the appellate tribunal shall be dealt with as quickly as possible and should be disposed of finally within 6 months. Within 6 months from the date of receipt of the appeal. Also, there's no provision in the Act for further appeal against the order that is passed by the appellate tribunal. However, the exception of the writ jurisdiction of High Court is there. Then, if we talk about the deposit of amount of the debt, wherever any party they want to file an appeal to the appellate tribunal, the defendant first they have to deposit 50% of the amount which is determined by the tribunal, right? So if the defendant they want to file an appeal with the appellate tribunal, first they need to make a deposit of 50% of the award which is decided by the DRT, and without such payment no appeal shall be filed. However, the tribunal they have the right to reduce or waive such payment to not less than 25% of the amount which is determined. So either 50% or in exceptional cases 25%, right? So, okay. Next, we have the procedure and the powers of the tribunal as well as the appellate tribunal. So, the tribunal and the appellate tribunal, they are not bound by the procedure which is laid down by the Civil Procedure Code. It is guided by the principles of natural justice, subject to the provisions of the Act and the rules, and they have the powers to regulate their own procedure. So, for the purpose of discharging their functions, the same powers of a civil court under the Code of Civil Procedure have been vested. And such powers are in respect of summoning and enforcing the attendance of any person, examining them on oath, requiring the discovery and production of the documents, receiving the evidence of affidavits, issuing commissions for the examination, and so on. They can also decide on the ex parte basis, that is on the basis of the evidence provided by only one party, the decision which is given, and no appeal shall lie against that, right? Then then requiring the evidence under the banker's book, appellate tribunal are deemed to be civil court, and so on. Then finally, we have the limitation. So for the application to be filed before the tribunal, the Limitation Act 1963 applies. We'll be studying about the Limitation Act, the law of limitation in Unit 23 of our Module C. So the Limitation Act applies and it says that the application must be normally filed by the bank or the financial institution within 3 years from the cause of action. So when the account it actually becomes an unpaid, or the dues they actually become unpaid dues, then within 3 years from the cause of action, then application should be filed by the bank or the financial institution. This is according to the Limitation Act of 1963. So we have seen that the banks has to file the application for the recovery of the loan dues under the DRT Act which have not been paid by the borrower, taking into consideration the jurisdiction and cause of the action, right? Also, other bankers or financial institutions that are also creditors to the same particular borrower can also join the application. It will be accompanied by the fees, documents, and the evidence. Also, if the transfer is made from the civil court to the tribunal, then no fresh fee is required to be paid to effect of law. So all of these provisions are very important. Also, the procedure for issuing the recovery certificate, provisions for the appeal to the appellate tribunal by paying 50% of the amount which is determined by the tribunal, which is to be deposited. Again, if the appellate tribunal, the decision that is taken by them is in favor of the defendant, then it will be paid back to them, right? And normally within 3 years of the cause of action, the application has to be filed by the bank or the financial institution. These are the important provisions for the procedure of the tribunals. All right, so let us begin. Today we have the Unit 18E from the Module C, which is the recovery of debts determined by tribunals and the miscellaneous provisions. So once the recovery certificate is passed by the tribunal, what is the procedure which is followed by them for the recovery? What are the modes of recovery available? Then is there any appeal that lies against the decision taken by the tribunal? what is the procedure for filing the appeal. All of these things we are going to discuss today. So let us start. First, in the section 25 of this act, it is clearly stated that when the recovery officer is receiving the copy of the recovery certificate, then what will happen? They will proceed to recover the amount which is specified. So the DRT, they're going to specify the amount which is to be recovered in the certificate, and what are the modes that are available to the appointed recovery officer for the same. They can by attachment and sale of the movable and immovable property of the defendants, or they can arrest the defendant and detention in prison, the appointment of a receiver for the management of the movable and the immovable properties, taking possession over any asset or property on which the security interest is created, and appointing a receiver and to sell the same, or any other mode of recovery which has been prescribed by the central government. So once the recovery officer, they receive the recovery certificate, right? So they can sell any property that is owned by the defendant. Also, the arrest provision of the defendant, it will be have to be made keeping in view the Supreme Court decision that it should not contradict the values stated under Article 21, right? So it should not be against the fundamental rights which are available to the people of India. Then, if we talk about the validity of the recovery certificate, so we have also earlier discussed that once the recovery certificate is passed, then the defendant is debarred from raising any dispute before the recovery officer about the correctness of the amount specified in the certificate. They cannot say that the amount which is mentioned in the award is incorrect, it is high, or it is unfair. They cannot make any dispute about the amount which is specified. And the recovery officer is not going to entertain any objection which is raised by the defendant on any other ground, right? The only option which is available to the defendant is that they can file an appeal, but they cannot complain anything to the recovery officer. They're just carrying out their duties which are mentioned in the recovery certificate by the authority. Also, the presiding officer of the tribunal who has issued the recovery certificate, they will authorize, only they are authorized to withdraw the certificate. Also, to correct any clerical or mathematical error in the certificate. So the recovery officer is not going to entertain any objection. If there is any objection regarding the regarding any mathematical error in the certificate or regarding the correctness of the certificate, then it will be dealt by the presiding officer of the tribunal. So any party, if they want to have a review of the order which is passed by the tribunal or which is given in the recovery certificate, on the ground that the error is apparent on the face of the record, it is right, clearly visible to the naked eye that there is an apparent error, a mathematical or a clerical error in the recovery certificate, then they can make the application for review within 60 days of passing the order or issuing the certificate. So they, when they receive the certificate within 60 days, they can file an application for review with the same tribunal. Along with the application, they will attach the affidavit verifying the contents. If there is any mathematical or clerical error, then the applicant will show that this is the correct information. This is the correct information which will be used for the review. Also, it is required that the opposite party is given a notice and a chance to be heard before the application is granted. Right? So, before the presiding officer makes any changes or any review, they will also give a chance to the opposite party to be heard. Right? So there can be the stay on the proceedings under the certificate, or it can be amended, or it can be withdrawn after the application for review has been made. So what is the procedure for that? notwithstanding that a certificate had been issued to the recovery officer, even though the certificate has been issued to the recovery officer, still the presiding officer may grant time for the payment of the amount if the defendant makes a payment of not less than 25%. If on the very first day they make a down payment of 25%, then additional time will be provided to the defendant, and only after that time the recovery officer is going to continue with the proceedings, with the selling of the property. So if the defendant makes a down payment of not less than 25% of the amount which is specified in the recovery certificate, and an unconditional undertaking that they will pay the balance within a reasonable time, so the presiding officer can put a temporary stay on the proceedings. So this power is given to the presiding officer of the tribunal. So yes, they are going to stay on the proceedings until the expiry of the time so granted, and the defendant they agree to pay the specified amount in the recovery certificate. If however they commit any default in the payment, then the proceedings will continue and the stay on the recovery proceedings shall be withdrawn. All right. So all of this information the presiding officer will provide it to the recovery officer. There are also certain other modes of recovery which are allowed, which are prescribed by the government, central government, apart from the ones that we had discussed in the beginning. But again, it is upon the discretion of the central government and the tribunal. All right. Then appeal against the order of the recovery officer in the recovery certificate. The appeal shall not lie in the case stating that the amount which is mentioned in the recovery certificate is incorrect. The appeal will be there only if any third party is aggrieved by the order which is passed by the tribunal. Right? So the recovery officer is given powers under section 25 and 28 to recover the amount. The defendant cannot question the or they cannot dispute before the recovery officer about the correctness of the amount which is mentioned. However, when a recovery officer attaches and sells the property, it is possible that any third party that is having interest in such property may get affected. So, any person that is aggrieved by the order of the recovery officer, they may appeal within 30 days to the tribunal. So, this 30 days will be counted from the day that they receive the copy of the order. All right. When the copy of the order is issued to the person, then on receipt of the appeal, the tribunal has to hear the appellant and make the inquiries as it deem fit. Thereafter, making the inquiries, the order of the recovery officer may either be confirmed or modified or set aside. All right. So an appeal is preferred against the order of the recovery officer in this manner. All right. Then, if we talk about the transfer of pending cases, in the very beginning, we discussed that the jurisdiction of the tribunal will start on the day it is established. The day it is established, not from the enactment of the act, but from the day a tribunal is established in a particular area. So, what if a case was started before the tribunal was set up and this case was under the civil court? Again, there can be two situations. Either the order has been passed by the civil court or the case is still pending in the civil court. So, what will happen here? So, the section 31 deals with the issue of transfer of the existing cases to the tribunals. So every suit or other proceeding which is pending before any court, immediately before the date of the establishment of a tribunal, being a suit or proceeding, the cause of action whereon it is based, then if it had arisen after such establishment within the jurisdiction of such tribunal, it shall stand transferred on that date to such tribunal. So if a case is pending, then it will be transferred to the DRT. All right. Only if the case is pending in a court and then a DRT is established in that area. So now the case will be transferred. It will now be under the jurisdiction of the tribunal. But it is very important to note that if there's a decree or order passed by any court before coming into operation the DRT Act and it is not yet executed, then the decree order may apply to the tribunal for the issue of the certificate. All right, so now what has happened? The award or the order is passed by the civil court. They have passed the decree, but it has not been executed. The order to sell the property has been given, but it has not been executed, it has not been started. Then the DRT will, the case will now be transferred to the DRT, but no fresh proceeding or trial will be taken. And on the basis of the order or the award, the recovery certificate will be created. So now the tribunal will have the responsibility of only issuing of the recovery certificate. There is no fresh trial or hearing in such cases, and the tribunal has to directly issue the recovery certificate, which is based on the decree of the civil court. Right? So if the case is pending in the civil court and no order has been passed, then the DRT will take over the proceedings. But if the case is not pending, it has been completed and an order or decree has been passed by the civil court, then only the execution of the order will be done by the tribunal. No fresh hearings or tribunals or proceedings or trials will be undertaken. These are the provisions. Then, if we talk about the protection of action taken in good faith, so any action which is taken by the central government, the presiding officer of a tribunal, or the chairperson of the appellate tribunal, or recovery officer, no suit will lie against these actions. So, when anything is done in good faith, then no suit, prosecution, or any proceeding shall lie against these entities. And this protection is given so that the authorities can function without fear as well as hindrances that the borrower otherwise can put. All right. So they are provided protection against any lawsuit or proceeding. Today we have the unit 19 from module C, Introduction to the Insolvency and Bankruptcy Code of 2016. Now, when we talk about the Insolvency and the Bankruptcy Code of 2016, which is also known as IBC. So, prior to the enactment of the IBC, India had multiple overlapping laws that governed the various facets of corporate rescue or the insolvency process, and there wasn't a comprehensive legal framework which could be applicable to the troubled or defaulting companies, right? So to solve this problem, the IBC code was brought. Now there are two terms in the IBC. First we have insolvency and then we have bankruptcy. So what is the meaning? The terms are related but different. Insolvency means when an individual or the organization is unable to meet its financial debt towards its lender and it becomes overdue. So the financial institutions or the banks, they identify that the company, organization or the individual are not paying their debts, and the insolvency can be resolved by changing the way or the repayment plan for the loans or writing a part thereof. So we are not selling off the property or we are not dissolving the organization. What we are doing, we are trying to restructure. Restructure. If only it cannot be resolved in the restructuring pattern, then a legal action may lie against the insolvent and then the assets will be sold off to pay off the outstanding debt. So first we will try to help the organization recover. There can be circumstances because of which the organization only temporarily is unable to pay off its debt. So, to make the organization profitable again, to enable it to pay off its debts and financial obligations, the insolvency resolution procedure may be taken. For this, an official assignee or liquidator appointed by the Government of India realizes the assets for the insolvent. Then, if we talk about bankruptcy, we know that insolvency is where the individual or corporate is unable to pay its debt, but the bankruptcy is where the individual or the organization they themselves declare as insolvent. It is a legal declaration either voluntarily by the debtor or at the instance of the creditor. They are saying that I have gone insolvent. Please sell off my property or recover the dues. So the bankruptcy is where the person voluntarily declares themselves as insolvent and goes to the court. So the court is responsible to liquidate the personal property of the insolvent and hand it over to the creditors. So here directly the legal procedure will be taken. So we have the difference between insolvency and bankruptcy, right? Then under the IBC, there are four pillars. We have the Insolvency and Bankruptcy Board of India. We have the National Company Law Appellate Tribunal, the NCLT and the NCLAT. We have the insolvency professionals and the information utilities. These are the four pillars that will take on the procedure of the CAIIB or the liquidation. So the insolvency professionals to assist the completion of insolvency resolution, the liquidation and the bankruptcy proceedings, and they will maintain the professional standards and codes of the ethics as the first level regulators. Then the information utilities are going to collect, collate and authenticate as well as disseminate the financial information. They will also maintain the electronic databases on the lenders and the terms of lending, right? Then we have the NCLT and the NCLAT, which are the adjudicating authorities. They are going to listen to the complaints, the cases relating to the insolvency of the corporate persons, right? So NCLT will hear the insolvency of the corporate persons. We also have the DRTs, which will be the forum for the insolvency related to individuals and partnership firms. Right, so NCLT related to the corporate, the limited liability entities, and DRT to the individuals and partnership firms. Along with them, we have the appellate bodies also, NCLAT and DRAT, where the higher appeal can be preferred on the orders of the NCLT or the DRT. All right. And we have the IBBI, the Insolvency and Bankruptcy Board of India, which will have the regulatory oversight over the insolvency professionals, agencies, as well as the information utilities. So these are the four pillars of the framework. Then we have the CIRP, the Corporate Insolvency Resolution Process. It can be initiated by the financial creditor or the operational creditor or the corporate debtor itself. Now you should know the difference between a financial creditor and the operational creditor, the financial debt and the operational debt. So financial creditor is where a financial debt is owed. Operational debt refers to the provisions of goods and services or employment in respect of payment of the dues arising. So both of these are different, right? So CIRP is the process for the insolvency resolution. All right. So it starts with the admission of application for the initiation of CIRP. Then the insolvency resolution professional is appointed. The committee of the creditors are constituted. And finally, the resolution professionals are appointed who will take on the process of the CIRP, right? So wherever the default is rupees 1 lakh, this amount has been increased to rupees 1 crore. Then the creditor may initiate the CIRP. There can be two independent stages here. First is the insolvency resolution process, where we are trying to resolve the situation, we are trying to provide a restructuring. However, if it does not work, or the financial creditors decide to wind down and distribute the assets to the debtor, then it will be known as the liquidation. So there are two stages, first stage and the second stage. So under the CIRP, the management can be changed or the restructuring can be made, or any step to revive the organization can be taken. All right. Then under the liquidation, simply the sale of the assets will be made in the market and the debtors will be paid from the arisings from that. Now, when this is the CIRP that we discussed, if the second stage of liquidation is taken, then how will be the proceeds of liquidation distributed among the various interested parties? For that, a very important mechanism, the waterfall mechanism, is used. It determines the priority. So whatever receipts are generated from the liquidation process, first they will be used to pay off the debt, pay off the insolvency resolution cost and the liquidation cost that was undertaken by the agency, the resolution professionals. Then second on the priority list are the workmen dues. All the people who were employed for 24 months before the commencement of the process, liquidation process, and debts to the secured creditor. And here the secured creditor has the option, either they can use their secured asset to recover their amount, or they can give it to the resolution professional who have relinquished. So this will known as the relinquished. So the secured creditor who have relinquished their security interest will be on the second priority. Then on the third, wages and unpaid dues to the employees will be paid off. Then the financial debts to the unsecured creditor and the workman's dues for the earlier period. The crown debts and debts to the secured creditor following the enforcement. Crown debts are those taxes which are owed to the government. Then the remaining debts, preference shareholders, and finally the equity shareholders or the partners are paid off. So this is the sequence which is followed, or the priority in which under which the payments will be made to the interested parties. And then we have certain other things like who can make an application, or persons who are not entitled to make an application. All of these things are important from this chapter. Then the moratorium period, the time limit, how the application will be made, or how the appeal can be made. These are the other details. The important ones we have discussed. We have also stated here the liquidation steps. Today we are going to cover the unit 20 from module C, which is the Bankers Books Evidence Act of 1891. So this is a very old act, and at that time there were no machines or computers, and all the details that were maintained in the various ledgers or registers, these were maintained in the handwritten form. And when any claim of the bank was required to establish or proved in the courts of law or any such other forum, then the books were required to be produced in original, and it was very difficult to do so. Therefore, its extracts and statements of the account are produced. So to facilitate the production of such evidence in an easy way and to have evidentiary value to the extracts and the copies, the Bankers Books Evidence Act was enacted. Also, it has been amended to include the printouts for today's copies that are maintained on the computer systems as well. All right. So, the Bankers Books includes all the ledgers, the day books, cash books, account books, and all the other records which are used in the ordinary business of a bank. So a bank needs to maintain various registers, all the informations of all the transactions. So all the types of records which are maintained are defined as the banker's books. Now, these records may be kept in the written form, as was done earlier, or they could be stored in a microfilm, magnetic tape, or in today's time, the mechanical way or electronic data retrieval mechanism. Also, such record can be either on site or at any off site location, and it includes a backup or disaster recovery site as well. So, when we talk about the applicability, so the act applies on all of these bankers' books. Bank or the banker can have the same meaning, any company or corporation carrying out the business of banking, and the act extends to the whole of India except the state of Jammu and Kashmir. Then, when we were discussing about the legal proceeding, so any proceeding in which the evidence may be given, an arbitration or investigation under the Code of Criminal Procedure or any other law, court, judge, trial, all the regular meeting. Then, another important definition is the certified copy. It means when the books of a bank, if maintained in the written form, then a copy of any entry in such books together with a certificate. Now, this certificate is important. When a copy of the original documents is taken as evidence to the court, then along with that copy, a certificate duly duly signed will be produced, and at the foot of such copy will be written that it is a true copy of the original entry, that such entry is contained in one of the ordinary books of the bank created during the ordinary business, that such entry was made in the ordinary course of business, that such book is still in the custody of the bank has not lost it, or it has not been destroyed. They still have the original records in its custody. And if the copy was obtained by a mechanical or other process, then it in itself ensures the accuracy of the copy. For that, a further certificate will be required. So, along with the copy, if it is a written form, a certificate stating that it is a true copy, plus if the copy was obtained by a mechanical process, then a further certificate that even that mechanical process was a true process, or the original documents are maintained. This is if the copy is maintained in a written form. If, let's say, the books of bank are maintained in the electronic form, then we will take out the printout as the evidence. So it should contain, the certified copy should consist of the printouts of the data which is stored in a floppy disk, tape, or any other electromagnetic data storage device. So we are taking a printout of the books which are maintained in the electronic form. Along with the printout, a copy of such printout, and it should contain the certificate having all the applicable contents. These contents that we just discussed here, this should also be there when we are taking a printout of the mechanical book, right? And this is if it is stored in the electronic form. If it is stored in a mechanical form, that is in a microfilm or a magnetic tape or any other form, then again the copy and the certificate having all the applicable details. So doesn't matter if the book was maintained in the written form, electronic form, or mechanical form, the copy or the printout, or if it is, let's say, taken in a pen drive, along with that a certificate that will ensure that it's a true copy and that the original documents are still in the custody of the bank and that they were created during the ordinary business of the bank. All of these things will be mentioned in the certificate. All right. So the conditions in the printout, for that the certificate will be taken, that the books of the banks as per section 2A when the books of the bank are not handwritten and the copies are taken by a way of printout. So what conditions should be followed when we are taking the printout as the evidence? So a certificate by the principal accountant or the manager to the effect that such printout or of the entry or a copy of the printout, that is a certificate certifying, and that certificate will be signed by the principal accountant or the manager that this printout is a printout or a copy, all right, and a certificate by the person in charge of the computer system will also be taken. Now this certificate that will be taken by the computer in charge, it will maintain that the safeguards are adopted by the system to ensure that the data entered or any other operation is done by the authorized person only. Also, safeguards are adopted to prevent and detect any unauthorized change of data. There is no third party breach. The arrangement for the storage and custody of such storage devices. The data is not lost due to systematic failure. The banks, they still have that data. All right, so the certificate from the accountant or the manager as well as the certificate from the person in charge for the system, for the computer system. Also, the certificate that the computer system installed is to the best of his knowledge. It is operated properly at the material time. He was provided with all the relevant data and the printout represents correctly and is appropriately derived from the relevant data. So even when we are taking the printout as evidence, all of these things will be ensured in the certificate. Then what is the mode of proof of certain entries in the banker's books? For that, again, a certified copy of any entry in the banker's book in all the legal proceedings will be received as a prima facie evidence of the existence of such entry. We are going to accept that that original entry is still with the bank. Further, it shall be admissible as evidence of all the matters, transactions, and accounts which are recorded as the original entry itself. All right. Yes. Then there was a very popular case, the Chandrahar Goswami versus Guwahati Bank, in which the Supreme Court had held that to make a person liable, mere entries in the books of the account are not sufficient, even though the accounts are kept and maintained in the regular course of business. There has to be further evidence to prove the payment of the money by the bank. So the bank, they have to present the receipts as well if required, which appears in the books of the account to make the person liable, except where the person, they accept that yes, the books of account, they are correct, the information that is provided is enough. Otherwise, the banks, they will have to provide further evidence to prove the payment of the money wherever the case be. All right. Now, if let's say in any proceeding where the bank is not a party, in any proceeding in the court or any other legal proceeding, the bank is not a party to that dispute, then no officer of a bank shall be compellable to produce any banker's books. So no officer of the bank will be compelled to produce the evidence, or they cannot be called as witness to prove the matters until and unless the bank or that individual is actually involved in the dispute, right? Also, the requirement of filing the original documents will be insisted upon only when the parties actually dispute the documents that are on record. If the parties say that the documents are incorrect or the information that is maintained is incorrect, then only the original documents will be produced. Otherwise, the copies or the printouts will be accepted, right? Then the inspection of books can also be done by the order of court or the judge on the application of any party to a legal proceeding. the court or the judge may order that the party be liable. They are at liberty to inspect and take copies of any entries in the banker's book. But for that, the order should be made by the court or the judge, right? So, within a time to be specified in the order, the certified copies of all such entries, accompanied by a further certificate that no other entries are to be found in the books of the bank, will be received. So, inspection is also allowed. Also, the costs of application to the court under or for the purpose of this act, or any cost which is done under the court, shall be in the discretion of the court, right? And the further, the court may order that such costs or part thereof to be paid by the bank to the party. All right, if the costs have occurred due to any fault or improper delay on part of the bank, then the costs will be borne by the bank to the party. Today we'll be covering the Unit 21 from Module C, the Legal Services Authorities Act of 1987, under which the Lok Adalats are formed. So let us start. Till now, we have been seeing the various acts in which the minimum amount of dispute arising has been given, that is above rupees 20 lakhs. Now what about those cases that are below rupees 20 lakhs, where the dispute is below rupees 20 lakhs? Or what about those individuals, those classes of people who cannot afford to pay the very high court fees, or those cases where the court intervention is not required and the dispute can be resolved only by mediation, arbitration, reconciliation? So all of these cases are dealt by the Lok Adalats, which is translated into the People's Court, right? So now let us start with the formal discussion. Okay, so as per the section 19(1) of the Legal Services Authorities Act of 1987, the Lok Adalats are organized by the state authority, the district authority, the Supreme Court Legal Services Committee, the High Court Legal Services Committee, or the Taluk Legal Services Committee. So at the state level, district level, Taluk level, the Lok Adalats can be established by these authorities whenever and wherever they feel that certain cases need to be resolved. The areas where they think fit, the Lok Adalats can be organized. If we talk about the jurisdiction of the Lok Adalat, which type of cases will be dealt by? So, a Lok Adalat shall have jurisdiction to determine and arrive at a compromise or settlement. So, those disputes that can be solved by a compromise or settlement between the parties, they will be taken up by the Lok Adalat. The dispute, either it can be a pending case before the court. The court, any court, if they feel that this case can be held or this case can be heard in the Lok Adalat, they can transfer that case to the Lok Adalat in the particular area. Or originally also cases can be taken to the Lok Adalat. So the pending cases before any court for which the Lok Adalat is organized, or a matter which is falling within the jurisdiction but not pending in any court. Now, a question might come in your mind: what if the person, the people, they had applied for the dispute resolution in a court and they had paid the fees? What will happen of this fees? Because the Lok Adalats, they do not charge any fee. If the case is transferred to the Lok Adalat and the Lok Adalat gives a solution, the dispute is resolved, then the fee will be refunded to the individual. The fee will be refunded to the parties only if the Lok Adalat is able to arrive at a solution. Only then, otherwise, the case will be sent back to the civil court, right? Then the offences which are compoundable under any law cannot be brought within the purview of the Lok Adalats. Or another way to reframe this sentence: only the non-compoundable cases will be taken up. Compoundable cases are those in which arbitration and mediation is not possible. For example, a criminal offense. If a very grave offense like a murder, if that is taken to the court, it cannot be solved by a arbitration or mediation. No person can be paid for their life. So these compoundable cases cannot be taken to the lok adalat. Only the non-compoundable, where dispute resolution through mediation or compromise is possible. And the monetary ceilings presently is rupees 20 lakh. So the civil disputes can be settled under the mechanism is presently rupees 20 lakh. Right? Now, the section 20 deals with the cognizance. When the Lok Adalats are going to accept any case, they are going to take the cognizance, and it points out that the Lok Adalats shall deal with the following types of cases. The disputes the parties agree to refer. If the two parties in dispute, they themselves agree that we will take this case to a Lok Adalat, not to a civil court, then or the disputes where one of the parties make an application. If party A and party B are in a dispute and party A says that I want to take it to the Lok Adalat, but before the Lok Adalat accepts this application, they are going to give a chance to the party B to be heard, right? They are going to give the chance to a party B to be heard. Then, if the civil court under which the case was pending, they feel that it is appropriate to be taken cognizance by the Lok Adalat, then where in respect of a potential dispute, the authority or the committee organizing the Lok Adalat, that is the state authority, district authority, the high court legal services, if they feel that on receipt on an application from any one of the parties, they are of the opinion that the matter needs to be determined by the Lok Adalat, then they can also refer it, but after giving an opportunity of hearing to the other party. All right. So this is how the various cases will reach the Lok Adalat, or where the Lok Adalat is going to accept it. Now, how is the Lok Adalat going to dispose the cases? They shall arrive at a compromise or settlement between the parties. They will act with utmost expedition to arrive the compromise, and they will be guided by the principle of justice, equity, fair play, and other legal principles, right? If, however, no compromise or settlement could be arrived at between the parties, then the record of the cases shall be returned to the court from which the reference was received. Now, again, a question might come to our mind. Now, how will the civil courts again take over the cases? Will they hear both the parties again, or will they start fresh proceedings, or are they going to continue from where they have left? So when no compromise or settlement is arrived, it will be referred back to the court, and the court shall proceed with the matter from the stage it had reached before making a reference to the Lok Adalat. So no fresh proceedings will be started. The point at which they had referred the case to the Lok Adalat, from that point only the court is going to continue with its proceedings, right? Also, if in the respect of disputes which were not before the court, and there is no compromise or settlement between the parties, even they can seek remedy in a court, right? So the court shall proceed with the matter from the state it had reached before making a reference. And if in respect of the disputes which were not before the court, and there's an absence of compromise or settlement, then the parties can also seek a remedy in a court. All right. Again, when we talk about the nature of award of the Lok Adalat, same, the Lok Adalat shall be deemed to be the decree of a civil court or any other order of any court, right? If any court fee is paid, we have already seen it will be refunded in the manner which is provided under the Court Fees Act if the solution is given or the compromise is reached by the Lok Adalat. So the Lok Adalat shall have the powers of summoning and enforcing the attendance, the discovery and production of any document, the reception of evidence on affidavits, the requisitioning of any public record or document of copy, any matters which may be prescribed. Also, the permanent Lok Adalats have also been established. The permanent Lok Adalat, which are added from 11 June 2002. This is for faster hearing of the cases. We are going to study the module C unit 22, the Consumer Protection Act. Now let us start with the Consumer Protection Act. So this Act of 2019 was enacted on August 9th, 2019, and it aims to provide for protection of the interests of the consumers and for the said purpose to establish the authorities for timely and effective administration. Now, in this definition or explanation, we can see three important terms. First, consumers. Consumers are those entities who are purchasing any goods or services. This act applies to both goods and services, and they are purchasing them for final consumption. So, any entity who tries to sell these goods off or they try to trade in these goods in the future, they won't be considered as consumers. Then we have stated that there are certain authorities. So we have the Consumer Protection Councils, the Consumer Dispute Resolutions, Redressal Councils, then the Consumer Protection Authority at the central level. All of these authorities are set up. And consumer disputes means whenever the seller, the manufacturer, they provide a good or a services that is of a faulty nature or it is hazardous to the health of the consumer and they knowingly do so, then the consumers can seek redressal from these authorities. All right. So the act came into force from July 20th, 2020, and certain other procedures like setting up of the CCPA came into effect from July 24th, 2020. So now the important definitions, provisions, all of these things we are going to see. Foremost, we have the definition of a consumer who buys any goods for consideration, means they are in return paying for it, right? And but it does not include a person who obtains such goods for resale or for any commercial purpose. Similarly, if the person hires or avails any service for the payment has been made or it will be made in the future as per the contract, again it does not include a person who avails such service for a commercial purpose. Now, another very important point, let's say the good that has been purchased by the entity, they are using it to earn income. It is their source of income. For example, a sewing machine that is purchased by a tailor. A sewing machine purchased by a tailor. Another incidence where a sewing machine is purchased by a retailer from the manufacturer. So in this case, this retailer will not be considered a consumer, but because the tailor is using the sewing machine to sew clothes, then they will be considered as a consumer and they can also apply for any complaints if faced. All right. Then if we talk about the rights that the consumers have, the rights that are secured, the right to be protected against the marketing of goods, products or services which are hazardous to life. For this very reason, all the products, the consumption goods, they have to mention the ingredients at the back of the packet. Also, if it is hazardous or if it contains anything that can cause allergy or irritation, for example, to the skin or to the eyes, everything has to be mentioned. Then the right to be informed about the quality, quantity, potency, purity, standard, and the price of the goods. Again, the consumer has protection against the unfair trade practices. The manufacturers, the companies, they cannot put an image on the package which is completely different from the actual product. The product images should match with the product inside. Then the price of the goods which is stated will be the price at which the product is sold. Higher than that cannot be charged. All of these will otherwise come under the unfair trade practices. They also have the right to be assured the access of a variety of goods, product or services. They have the right to be heard, that the consumer's interests will receive due consideration. They also have the right to seek redressal against the unfair trade practice. For example, if a retailer is selling the good at a higher price than what is mentioned, then the consumer can raise a complaint. Or if they are charged for a service which otherwise was free of charge, then also they can make a complaint. And they have the right to consumer awareness, which means the advertisements or any newspaper article, they should contain the correct information regarding the product or the service. Now, when we talk about a defect and a deficiency, defect means a fault, imperfection or shortcoming in the quality, quantity, potency or any other standard in the good or the product, right? Which is to be required to be maintained by or under the law. Deficiency is when we talk about the fault, imperfection in terms of a service. In terms of a service. So, if the law requires the manufacturer, the retailer, or any service provider to provide certain quality of the services or the products, and if it is not followed, then the consumer can file a dispute or a complaint, right? So deficiency, we have seen any act of negligence or omission or commission by such person which causes loss or injury to the consumer, or they are deliberately withholding any relevant information, right? Then we have various regulators and authorities and so on. So the various authorities which are set up for the protection of the consumer against the unfair contract and the unfair trade practices, like the falsely representing that the goods are of a particular standard or that the services are of a particular quality or grade, falsely representing any rebuilt or second-hand good as new goods, or represent that the goods or services have sponsorship or approval. Let's say any particular beauty product is sold in the market stating that it is doctor approved when it is actually not, right? Making a false or misleading representation. All right. So all of these will be treated as the unfair trade practices. Now, to protect the rights of the consumers, the consumer protection councils are set up at the central, state, and the district level. The central, state, and district level have their own jurisdiction, right? So the jurisdiction of the district commission, state commission, national commission is also given. First, we will see the Central Consumer Protection Authority. Central Consumer Protection Authority, which shall consist of a chief commissioner and any other members, other commissioners which will be appointed by the central government. It will also have the investigation wing. So the central authority is going to protect, promote and enforce the rights of the consumers. They're also going to take steps to prevent the unfair trade practices. They're going to ensure that no false or misleading advertisement is made of a good or a service which actually contravenes the provisions. And no person takes part in the publication of an advertisement which is false or misleading. So they are going to issue directions to the concerned trader, manufacturer, endorser or advertiser to either discontinue a false or misleading advertisement. They're going to issue the safety notices to the consumers against the unsafe goods and services. impose the penalties if the cases are proven, and investigate the violations of consumer rights. They're going to pass orders to recall the goods or withdraw the services that are hazardous. Also, they're going to reimburse the price which is paid and discontinue the unfair trade practices, right? So, all of these are the rights to the consumers: the right to seek justice in a time bound manner, right to seek redressal against the unfair or restrictive trade practices, all the rights that we have already discussed. Then, like I said, we have the consumer protection councils at the district, state, and central level. The members are given as well as the meetings. So, the district council chairperson, other members prescribed by the state government, and they should meet not less than 2 times in a year. The state council, again, the chairperson, members which are prescribed by the state government, and 10 members will be nominated by the central government, meeting at least two in a year. And the central council will have members, chairperson, vice chairpersons, and other members, and they should meet at least once in a year. So, at all the three levels, they shall meet as and when necessary, and they are going to observe the procedure with regard to the transactions of the business as may be prescribed. Then we have already seen the Central Consumer Protection Authority. Then we also have the District, State, and National Consumer Disputes Redressal Commission. Dispute Redressal Commission. So they are going to see the complaints which are heard subject to the terms and conditions brought out in the Act. Now there are certain jurisdictions which have been decided, and these jurisdictions have also been revised. So the Ministry of Consumer Affairs, Food and Public Distribution, under the Department of Consumer Affairs, they have given out a notification on 30th December 2021, which has revised the jurisdiction of the district, state, and national commission. So the complaints of disputes which are going to be heard by the district commission, where the value of the goods or services paid as consideration does not exceed 50 lakh rupees. The state commission will hear the disputes where the value of the goods and services does not exceed 2 crore rupees, that is between 50 lakh and 2 crore. And the National Commission is going to hear the disputes where the value of the goods and services exceeds rupees 2 crore. So this is a very important amendment that has been made, a revision that has been made, and you should remember it because many times the institution has asked us questions. Also, there is the consumer mediation cell, which is going to undertake the mediation. So it is going to have a list of impaneled mediators, a list of the cases handled by the cell, the record of the proceedings, and any other information. And today we have the unit 23 from module C, which is the law of limitation. So when we talk about the law of limitation, under various acts like the recovery of debts due to banks and financial institution, or we have also seen in the SARFAESI Act, these acts they specifically state that those actions are permissible only if the claims are within the period of limitation, right? So the limitation law or the law of limitation basically tells us the time period within which the claims can be filed, and only then they will be entertained. So now let us start. Like I said, the Limitation Act of 1963 has significant application to the banks and financial institutions. It provides these entities, they provide financial assistance to the borrowers. Also, they are required to take appropriate action for the recovery of the money lent. So, the 1963 Act to consolidate and amend the law of limitation of suits and other proceedings. So, this Act tells us the various time limits prescribed within which the claims can be filed. Right. So there are certain important definitions under the Act. For example, all of these definitions are given in the section 2 of the Limitation Act of 1963. Applicant includes a petitioner or any person from whom or through whom an application the applicant derives his right to apply, or any person who is acting as the representative of the applicant. So the executor, administrator, or any representative. Then we have the defendant against whom the application has been filed. So a person from or through whom a defendant derives his liability to be sued. Any person whose estate is represented by the defendant as the executor, administrator, or other representative. Then we have plaintiff, any person from or through whom a plaintiff derives a right to sue. Or again, any executor, administrator, or representative on their behalf. The most important definition is the definition of the period of limitation, which is always in relation to a right, whether arising out of a document or otherwise, which entitles the person having the right or the beneficiary to take action in a court of law. For example, if any bank or a financial institution, they want to get their loans recovered, they have to apply within a time period, like let's say 3 years or 12 years, as the case may be, when the account became a NPA, right? So the period of limitation prescribed for a suit, appeal, or application by the schedule, and the prescribed period means the period of limitation which is computed, right? So these are the various important definitions. Now, what is the limitation period, or how is it computed? The computation of the period of limitation, what all period will be included or excluded when we count the days within which the application can be filed. Let's say within 30 days an appeal has to be made, or within 90 days the decision has to be given. So what are days are we going to exclude from it? So when the period of limitation expires on a day when the court is closed, so it is not something in the hands of the applicant, then the suit, appeal, or application will be preferred on the day when the court reopens. So the day when the court is closed will be excluded. Then any appeal or any application other than execution petitions may be admitted after the prescribed period if the appellant provides a sufficient cause for not preferring. Let's say the appellant says that I was out of India, or I was not well, I was not in the medical condition to make the appeal. Also, in computing the period of limitation, the day from which such period is to be reckoned shall be excluded. The day on which the account becomes an NPA will be excluded, and we will count the period of limitation from the very next day. All right. Then the period during which the institution or the execution has been stayed by an order. If the court has put a stay on the institution or any work of the institution, then again that day will be excluded. The day on which the order was made and the day on which it was withdrawn shall be excluded. Then the time that is required for obtaining such consent or sanction shall be excluded. For example, for filing any suit for which a notice has to be given to the court or any authority, then the time that is required for getting that consent or the sanction will also be excluded. Also, a very important point, the time during which the defendant has been absent from India and from the territories as well. Not just the geographical boundaries of India, but the international waters also, which are under the administration of central government. If the defendant has been absent from those, then it shall be excluded. All right. So in the computing the period of limitation for any suit, these days will be excluded, and then we are going to calculate the period of limitation. All right. There are also instances which will give rise to the fresh period of limitation. For example, where before the expiration of the prescribed period in respect of any property or any right, an acknowledgement of liability has been made, then a fresh period of limitation shall be computed. Also, if let's say a payment on the account of a debt or of interest is made before expiration, then again it will give rise to a fresh period of limitation. All right. So this is how we are going to calculate or compute the limitation period. Now we have been provided a very important table in which certain provisions in the schedule to the Limitation Act is given. So we have around, right. So various description of the suits have been given, the period of limitation and the time from which the period begins to run. From this table, the questions will be asked from the period of limitation. So here in this table, you can see that for all of these 6 type of suits, the period of limitation is 3 years. So it is similar for all the suits. Then for others also, other 3, also 3 years. So what we are going to do, we are going to remember only 5 that do not have the period of limitation as 3 years. That is, they have a different period of limitation. For example, to enforce the payment of money secured by a mortgage or otherwise, 12 years. So under this, again similar, we have, if we want to enforce the payment of money secured by a mortgage, then for a foreclosure, the period of limitation is 30 years. And for the possession of immovable property, it is 12 years. So 2 points that what we are going to remember. For foreclosure, it is 30 years. And for movable properties possession, it is 12 years. Then apart from these, again 3 years, 30 years, any suit for which no limitation has been provided. For the execution of a decree, 12 years. Appeal to file high court against the judgment of the lower court. Against appeal to file in any other court against judgment of a lower court. Right? So we have foreclosure, we have mortgage or possession of the immovable property. Then we have the execution of a decree. Execution of a decree. No period has been provided. And for appeal to the High Court and appeal to the any other court. Any other court. So these are the only 6 that we need to remember. Other than that, all the type of suits are having the period of limitation as 3 years. So the recovery of loss caused by a fraud or any suit on behalf of the central government or state government, promissory note, arrears of rent, specific performance of a contract, for the balance due on a mutual or a current account, money payable towards money lent under the agreement, money deposited under the agreement, payable on the demand, bill of exchange or the promissory note. All of these have the period of limitation as 3 years, and only the 6 that we have written here are going to have different. So foreclosure, we have 30 years, 30 years for foreclosure. Immovable property mortgage, we have 12 years. Decree, again, any suit, if we want to execute a decree, then we have 12 years. Where no period of limitation has been stated, again 30 years. Appeal to the High Court, 90 days. And appeal to any other court, 30 days. So if we remember only these 6, others we can simply, without any doubt, mark the correct answer as 3 years. So use this trick to remember the period of limitation, and you will easily score if any question is asked from this particular topic. And today we are going to discuss the Unit 24 from Module C. This is the last unit from Module C, the tax laws. When we talk about the tax laws, we have certain important taxes like the income tax, the commodity transaction tax, and the goods and services tax, right? Also, the banks and financial institutions are required to implement the provisions of the tax laws by, for example, deducting the taxes at source, or by crediting the tax deducted at source to the income tax authorities. And they also have to comply with the provisions related to the goods and service tax in their day-to-day operations. That is why we are studying this chapter. So first we have the Income Tax Act. We already know that the tax structure in India is divided into the direct taxes and the indirect taxes. Income tax is a type of direct tax in which the burden cannot be shifted. It falls on the same person on which it is levied, right? So the Income Tax Act of 1961, it came into force from April 1st, 1962, and it governs the law relating to taxation on income of the individuals, the corporates, etc., on the basis of the residence and the place of source of income. So any individual who is a resident of India, or a corporate who is a resident of India and their source of income is India, they will be taxed under the Income Tax Act. All right. So the income will include the profit and gains, dividend, or any profit, right? When they're ordinarily residing in India. All right. If we are talking about the corporate society, so the profits and the gains of any business carried on by the cooperative society with its members, any winnings from lotteries, crossword puzzles, all of these things will be included when we are calculating the total income of the individual. So the income, now other important definitions, we have the assessee, the income occurring or arising to a person. So for that person for which we are assessing the income, calculating the income is the assessee, is taxed on the basis of assessment year. If you have followed the latest budget developments, you'll see that these terms, the assessment year, financial year, previous year, these have been simplified by adding the term tax year. So to avoid the confusion of what is the meaning of assessment year, how is it related to the financial year, simply we are going to use the term tax year from now. But in our syllabus, these terms are given, so we'll try to understand them as well. So the term assessment year represents the period of 12 months beginning from 1st April every year, and the income arising in the previous year will be assessed in the assessment year. So income that we are earning, or the income that is arising in the previous year, will be taxed and paid in the assessment year. So the previous year means the financial year immediately preceding the assessment year. All right. So if we are deciding on the assessment year for the taxes to be paid in 2025, our previous year will be the financial year preceding the 2025-26 period. All right. If let's say a profession is newly set up or a source of income is newly coming into existence in the said financial year, then the previous year shall be the period beginning with the date of setting up of the business, or the date the source of income newly coming into existence, right? And the previous year will end with the said financial year. All right. So this is how we are going to calculate the income in the previous year and assess the tax on it, right? Then when we talk about the residential status, so when we are deciding whether the income is taxable under the income tax or not, it doesn't depend on the nationality or citizenship. It depends upon the residential status of the assessee, which is determined on the basis of the number of days an assessee was present in India during the previous year. So if in the previous year, let's say 2023-24, the person was present for 182 days in India, and they are earning income from any source, that income will be taxed as per our Income Tax Act. In the case of corporates, it is determined on the basis of location of control and management of the company and also the place of registration. So, if any company is registered under the, let's say, Companies Act of 2013, then the corporate will be treated as the resident and the income will be taxed. When a company, let's say, is an Indian company and it is registered under the Companies Act of India, or if it is a body corporate set up by a statute or a company whose control and management is based in India, then the company will be treated as a resident in India. And that company's income or the profits will be taxed. All right. Then when we talk about the computation of income, the total income that will be taxed. So the Income Tax Act envisages the following heads. We have salaries of the individual, income from the house property, profits and gains from business or profession, any capital gains, short term or long term, and income from other sources. So what we are going to do, we are going to compute separately the income arising under the various heads as per the relevant sections. Then after computing the income, we are going to calculate the gross total income. After adding all of these, we will arrive at the gross total income. And then the Income Tax Act, as per the slabs and the cess, if any applicable, the given rates will be calculated. Now again, we have the old tax regime and the new tax regime. Also, the budget has introduced a completely new taxation, but we will study what is given in our syllabus. Now, there are certain incomes which are not included in the taxable income, like foremost we have the agriculture income, or any sum which is received by an individual as a member of the Hindu undivided family, which is paid out of the income of the estate belonging to the family, right? So these incomes will be excluded from the calculation of the total or computation of the income, right? Then the banks accordingly will see what is the TDS, how the TDS will be collected by the banks, and it will be transferred to the account of the authority. However, non-compliance with the provisions relating to TDS is going to have a levy, as well as the recovery of the tax deductible will be from the person who is responsible for the deduction. For example, the bank, if they omit and they do not deduct the tax and they do not transfer it to the government's account, then they will be responsible to pay. Also, the non-payment of the tax deducted at source to the government attracts the prosecution proceedings as well, and imprisonment from 3 years to 7, from 3 months to 7 years, right? So these are the provisions of the Income Tax Act. Then we have the Commodity Transaction Tax, which was introduced under the Chapter 7 of the Finance Act of 2013. It means the tax which is leviable on the taxable commodities transaction. So we are talking about the tradable, marketable commodities. So the commodity derivative can be a contract for the delivery of good, which is not a ready delivery contract, or a contract for differences which arise from the prices and the indices, that is the derivatives. So any underlying good related activity, any derivative will also be included. And the taxable commodities transaction means a transaction of a, let's say, sale of commodity derivatives based on the prices. So on those sale of the commodity derivative, the commodity transaction tax will have to be paid. And in this scenario, the entity responsible for collecting this tax will be the recognized stock exchange. So the law makes the recognized stock exchange dealing in the commodity trading responsible for the collection of the commodities transaction tax from the seller who enters into the taxable commodities transaction at the rate which is specified, right? So the recognized stock exchange on which the commodity trading has been done, they will collect the tax from the seller. Then the tax which is collected during the calendar month shall be paid by the stock exchange to the credit of the central government by the seventh day of the month immediately following the said calendar month. So if the tax is collected in February, it has to be credited to the government's account by 7th of March. If, however, any assessee fails to collect the tax, shall be liable to pay the tax to the credit under the provisions. So similarly, if for example under the TDS, the bank fails to credit or collect the tax, then they will be responsible. Similarly, here the recognized stock exchange will be responsible to make the credit to the central government, and the taxes, penalties will be applied as such given in the act. All right. Third important act is the goods and services tax. We already know all the indirect taxes that were earlier implemented. They have been replaced by the GST, which is a destination based tax. It is a destination based tax. It has simplified the taxation procedure, although it has certain deficiencies which are again discussed to be covered under the new budget in the budget session. So if we talk about the GST, it is one indirect tax for the whole nation under the One Nation One Tax, which was enacted on April 12th, 2017. So it is a single tax on the supply of goods and services right from the manufacturer to the consumer. So now the consumer will have to pay only the tax on the value added finally by the seller. They will not have to pay the tax at each and every level of value addition. So this is going to simplify the tax payment for the consumer. So the GST is levied under the state GST, central, and the integrated. So the GST levied by the center on the intra-state, that is between two states, supply of goods and services is known as the central GST. The GST which is levied by the state or the union territory within the state, that is known as the SGST or UTGST. And similarly, the interstate supply of goods and services will be the integrated GST. And on the imports as well, the integrated GST is going to apply. The integrated goods and services tax is going to apply on the imports as well. All right. So the GST is going to have the benefits for the final consumer, the government, as well as the manufacturer. The final consumer will bear only the GST which is charged by the last dealer in the supply chain, right? The central and state government will have easy compliance, uniformity of the tax rates, removal of the cascading taxes, right? This will also be the benefit to the business and the industry. This GST will be simple and easy to administer, and the government is going to have better controls on the leakage, high revenue efficiency, and so on. So that is all for today. We have completed the revision of this module. And now, if you want to join us for the last minute revision, enroll now for the BRBL capsule batch. This batch is available both in bilingual as well as English medium. You are going to get 12 plus hours of live marathon sessions, downloadable class notes for your quick revision, 10 full-length BRBL mock tests that you can access anytime, and the sessions will be during the non-banking hours, so do not miss any of the live classes. This will be the best strategy for your last minute revision. If you haven't yet subscribed to the channel, so subscribe to the Olive Board JIB CIB English Medium channel. Like the video, share the video, and on a daily basis, we are bringing these important sessions for you. So I will see you in the next session. Thank you so much and all the best.